Not even I dare.
What's good, ladies and gentlemen? We are back in the building. Yeah, I gotta go. It's a cord that I need to buy so I can come live. Is even a mic inside there? Oh, it is. Come live at you. I got the switchboard here. All the switchboard. I got all that, the different effects. So I can show clips and all that. Do a little. But there's a cord that I'm missing that runs into this MacBook that I don't have. And I need that cord. Or else this will just be here for show. So, with that being said, today is Friday, February 7th. Valentine's Day is a week. Oh, and it's a Friday too. A week from today, Valentine's Day. You and your significant others, go ahead and do your thing. Or if you're not in a relationship, you can still go do your thing and make the best of it. Shout out to Big D, another member of the Supreme Elite team, has gotten another victory. They've been rolling lately. First, he got his interest with the IRS recognized and credited. Then he had, what is this? An account, looks like a credit card account set off. That's big. Set off the account, had it evidenced at the credit agencies. That's good. Progress. That's what I like to see. That's what I like to see. A lot of people still think it's about me. The one, what's going on? Tap in with me, the one, tap in. A lot of people still think it's about me. It ain't about me. It is not about me. Because I'm going to make a way regardless. I'm going to get mine regardless. Regardless, whether this or out in the I'm going to get mine regardless. So that's ain't about me. It's about the people who want to understand this from a professional level. That's why we call it, the name of the title of the video is Legal Claim versus an Ideology. The one, tap in, quick. Hurry up, quick. You gotta get it. A legal claim versus an ideology. A legal claim versus an ideology. And that is the topic of today's, because the reason why I contrast those two together is because when you make a legal claim, there are certain elements. Self-made was good. The likes on it. There's certain elements that it's like it's like with a legal claim, it's certain elements that it's like you can't you can't get around. Like there are legal standards, legal requirements, right? And it has to pass the legal threshold in order for you to have your claim heard. It's like the right to set off. We're resuming class tonight at 6:30. Between 6:30 and 7. Y'all know y'all gotta give me that 30, 45-minute grace period because I'm transitioning my household at that time. But I don't know why I just go to the office. I don't know why I just don't go to the office. Oh, kids in school at that time. The time frames don't allow for it. But when you make a legal claim, when you make a legal claim, you kind of there's certain guidelines that you gotta stay in the confines of. And if you operate outside of those guidelines, then it's no surprise that your claim could be rejected, not heard, not respected, not taken serious. So we want to avoid those. Set in tone. Legal claims are set in stone. They are what they are. Now, an ideology, it's a totally different ball game. An ideology can have pieces of legal standards mixed in with what we believe happened. And what we say happened is the truth, whole truth, nothing but the truth. And in a legal setting, regardless if you have 5,000 affidavits, notices after notice, whatever, what you got to understand is these people system, they're not just going to say, okay, we believe you just because you said this happened. So the ideology is a claim or presentment that's put together based on some type of religious point of view or some type of association point of view. That's why they call them like manifestos. And the difference between that and a legal claim is there is no legal standards or legal guidelines that you can use to measure your claim that's based more on ideology. Your claim, when it's based on ideology, it's only what you believe happened, what you think happened, how you see it, how you was taught to see it, and that's it. There's nothing that you can hold it up against that's like a qualifier. So let's say you have a process, which let me find one of them. The discharge and bond, right? You have the discharge and bond process, then you go right to set off claim. There are things that are legally on that side that has to be met from a legal standpoint. Rather, if you go to the discharging bond is just based on a set of instructions on what to do. Now, when you put those instructions up against the legal system, you'll realize that these instructions all come back to what someone believes to be true, what someone thinks is true. was someone as adopted as their reality. That's why I call it an ideology process. So I think it's important that we're able to differentiate a process that's based on or presentment or claim. Let's say claim. A claim that's based on a legal standpoint versus a claim that is rooted in an ideology. Because a claim that's rooted in ideology, it's hard for anyone to tell you, no, that's not true. Uh, versus a legal standpoint, you kind of got guidelines that'll be like, nah, this ain't correct. Nah, this is correct. Nah. When it's an ideology, there is nothing that you can tell that person, that claimant, that this isn't correct because they're not using the legal standards. They're using a belief system. And we all have our own belief systems, like religion. Everybody has their belief about religion. A Christian, Buddhism, Hindu, Muslim, Catholic, what's the other one? Yeah, y'all know all the different religions. One thing that they all have in common, besides the universal laws and principles, I think the universal laws and principles, I think they're pretty much uniform throughout every religion, from what I've read. But another thing that they all have in common is every single one of those religions, they all claim they are the one true religion. Whether it's the Prophet Muhammad sallallahu wasallam, be respectful to my Muslim, whether it's the Prophet Muhammad or you got Jesus Christ, whatever one you're at, whatever side of the fence you on, you still have one thing in common, that this is the right way. Now, when it gets to the like religion, it's all based on what you believe. If you believe Muslims the right way, you're going to die that way. You believe Christians the right way, you're going to die. That's what you believe. See, no one can tell you your belief is wrong in that aspect. You see what I'm saying? There's nothing that you can use as a measuring stick that says your belief is wrong. Your belief is wrong. I know, man, you might go to your religious books and documents, historical documents, but that's pretty much a personal decision that one makes, in which you're entitled to. So everybody's religion is correct according to how they see it. Nothing wrong there. The problem is when we adopt those same ideologies and beliefs and start imposing them in our legal transactions and claims. Not the religious. I'm not saying you're adopting the religious aspect. That's not what I'm saying. What I'm saying is when you're adopting these steps, these ideologies, these claims that have the hallmarks of something similar to a religious belief. It's like it has the elements. So when you present these claims based solely on what you believe is true versus this is meet the legal standards definition of truth, then we run into problems. This is why I say a lot of people are approaching these things, teachers too, they're approaching these things from a ideology. That's a mindset. That's a belief system. Okay? Hold on one second. All right, hold on 1 second, y'all. Okay, so when we start sending things to these professionals based on what we believe is true and not showing them the legal standards that you met, then we run into a lot of problems. Because uh, I don't believe there's anyone who subscribes to those talking points. I truly don't believe any of them have studied anything outside of the revisionist history on what someone else said, how it went, on what this teacher said, how it went. I don't think anyone else has dug deeper, because if they did, they would have realized that all that shit is dead on arrival. I don't think they did. Oh, hold on 1 second, y'all. I forgot to let y'all know this.
You're rocking with the best. You're rocking with the best.
Shout out to Yusuf L. Hey, I'm checking you out, brother. I see you've been learning a few things from me. That's good shit, bro. Yeah. Keep up the good work, Yusuf L. I see you learning a lot from me. Keep up the good work. Coach MT, you learning a lot from me. Keep up the good work. Remember, if y'all need a one-on-one teaching of this so I can really put you together, and the other guy, I forgot your names, because when y'all start using my talking points, y'all getting into it, but when it gets down to like the real X's and O's and explaining it, y'all kind of ad-libbing a little bit. Y'all ain't getting real detail. Like you really supposed to get in detail and be able to pinpoint exactly so you could create a picture and then take the legal standpoint and then transpose it back on your audience and put all that legal mumbo jumbo stuff in layman's terms. See, if y'all get up with me privately, I'll show you how to do that. Right? Because y'all, it's like you're throwing it out there, and then when it's time to, it's like y'all don't. So then you want to. It's like y'all got it. You can't freestyle this, y'all. Everything is strictly by the book. You can't freestyle it. All right, y'all. So hit me up behind the scenes, and then we can work on something, man. But shout out to y'all, man. Shout out to y'all. I know y'all been watching me. Y'all been taking notes. Only thing I ask y'all, Yusuf L, Coach MT, I just ask you one thing. It's okay. Just say my name. Like, it's okay to be like, yo, this brother Thomas Legacy, man, he made a good point, y'all. I think we should start. Y'all don't have to present it like you just found it out last week. Because I'm not saying I'm the only one that knows this. I like to limit it back to specific time frames and moments and times and what everybody else is talking about in those moments and the consistencies of those moments. Most people, they not saying securities. They weren't doing none of this. I'm not saying it's correlation, but you can, when I started it, because before I started bringing it up, I wasn't seeing nobody in mass like a lot of these teachers that you really know, Jonah Bays and all them. They wasn't doing. It's kind of like, oh, the timing and the switching of your rhetoric it's the timing of it is interesting. Shout out to those who's been going into those groups and letting them know who they learning from. Shout out to those. Shout out to y'all. I'm not the master teacher. I'm not the grand teacher of it all. I'm not. Never claimed to be. Never claimed to know it all. It's impossible to know it all. But when I'm saying when you see people and their arrow, their position, their talking points is always consistent in these ways, and then you see fast pivot or a shift is like, and then I look around to see who else is doing it. Maybe because I know I can't be the only one. So I'm looking around and I'm looking around like, I really don't, the landscape, I really don't see anyone else like on a consistent. But then one thing I have noticed about all those teachers who are using my talking points, it's obvious that they don't have the true deep research like understanding of it, because certain things that I watch them and they say, I'd be like, this will be a good opportunity for you to go dive more into it, and they always like leave it at the surface. So as the viewer and the student, you're left without that connection. So that's why I'm saying, like, if you're going to, one thing you can't do, was what I think is a recipe for the disaster, and I'm not saying you teachers are doing this, is no way that you can just take a little bit from someone, start spewing it out, and then try to make up the rest as you go, because this takes a lot of deep understanding and research. And even if your minds are like sponges, a wizard, there's no way that you all understand the whole post-transaction process and procedure that fast. No way you do. No way you do. No way you do. No way you know how to read balance sheets that fast. When I've never heard any of you all talk about balance sheets. I've never, nobody else has brought this up. So if you're a wizard at that, then I need to see what you would show me some of your tricks of the trades. This is why they can say what they want. People can say what they want, but I am the biggest influencer in this space. I am the biggest influencer in this space. Not going to give me the credit because this space is rather competitive. They're not going to say they got it from me. But I'm one of the biggest influencers. I've made teachers change their whole shit up. I made teachers change. I made teachers stop talking about certain forms. I made them stop. You don't hear HJR 192 like that, do you? From the prominent ones, y'all know. Ones that I don't know, whatever. You don't hear HJR 192. You don't hear that, do you? You don't hear that, do you? Imagine how that just stopped. Notice how that just stopped. Notice how 1099A just stopped. So, so just mention the wage statements in the group should be blank. These people did the same W-4, don't receipts, getting their tax refund, that's a Medicaid back to the 1040, and it's one. All from last year, getting their returns in 30 days or whatever. Guess where they got it from? They never tell you, like, right? They never tell. I was about to tell you, I know Tamika been stealing, acting like she got magic remedy to the blank. Then you just posted in the group, stay away from these type of people. That's crazy work. I said I seen that verbiage on their sworn statements from somewhere. Looked too familiar for them to come up with it on their own. Right. And telling people to claim the entire income that was paid and the Fed tax back. That's what's really got them fucked up more. So this is Tamika biting off me. This is someone texting me about Tamika biting me. Biting me. Tamika's my biggest student. Tamika, you might as well just go live with me. From Past to Freedom, you might as well just go live with me. I'm your biggest influencer. Shout out to Tamika for Past to Freedoms, y'all. Shout out to Tamika. Hey, Tamika, I do want to get a purchase order service from you. I want to get the purchase order from you. All I gotta do is express the trust, right? And then the money's gonna come out. My Sesty KV trust, Tamika, Thomas Legacy, whatever the price that you charging me, I'll pay it. I want the process. I want to be a client. I want to see. So when you take my business, please do. I want to get that purchase order. I want to buy a vehicle just using the purchase order. I want to drive off the lot like you with the purchase order. Yeah. Now, before I consult with you, Tamika, I want you to be straight up with me. Do I still have to use my own money with the purchase order? Or is the purchase order just good enough and I don't got to pay my own money? Because Tamika, I'm just trying to get free shit that I ain't got to pay for. So if you got that type of remedy for me, please send me an email. I'm dead serious. I don't want to pay for shit anymore. I don't want to recoup any proceeds. I just want to get free shit and I don't got to ever pay for it ever again in life, because there's this big trust in a TDA account that I can just buy all my shit from that. So Tamika, reach out to me. Reach out to me. Send me a private email. I'm going to get the purchase order process from you. See what we can do. Right, and telling them to claim the entire income that was paid. IRS sent their ass a bill in frivolous filing, but they never showed it to the people. Yeah, she was like, you can get all back off the income. Still, you try to steal my talking point. Still give wrong information. Get a frivolous filing, and then hide the frivolous filing like it never happened. Damn, that's ice cold. Yeah, that's ice cold. That's ice cold. God damn. Yeah, but Tamika, I want to get that purchase order. If you really purchase that vehicle with a purchase order, I want to get it. I want that process. I think it's $1,500. I got a $1,500 for you. I want to get that process. I'm not even going to bring up Cora B calling the dealership and saying, nah, you pay cash money for it. I ain't going to bring that up. But if you got the real way to do it and you perfected it, all right. Has anyone seen Alicia Hinton? Where's Alicia Hinton go? Where's Alicia Hinton? Where's Alicia? I need some tax services from you, Alicia. I need $2.5 million. I need you to make that happen for me. I want the 2.5 million. I got my trust set up and everything. Alicia, you reach out to me. I want the 2.5 M's. I want the 2.5. All right. And I got about 50 people that's willing to pay you right now for that $2.5 million process. Let's get it. Coach MT, I need 1099A services, Coach MT. I swear to God, I need it. Please let me know. Taquan X, I'm trying to get a vehicle and never make the first payment and still keep the vehicle. Taquan X, get out with me. Get out with me. Come on, y'all. All these teachers, yo, I need services. Why don't you teachers that want to give me services? Why can't I get services? My money ain't good with y'all. Why can't I get services? I'm trying to support the community. Black-owned businesses. I can't get the support. Y'all trying to block me from supporting y'all? Like my money ain't good in the hood? Come on, y'all. Like this motherfucker won't swipe. Like this motherfucker won't swipe. This motherfucker, hey, this A1, this good in the hood right here. Come on now. I want some services. Shit. Thomas Legacy 603 at gmail.com. Yusuf, I want to be in the secure party creditor school. Jonah Bay, I want that injunction. Tamika, I want that purchase order. Coach M and T and all that. I want that goddamn 1099A class because nobody knows how to do it right. And Alicia Hen, I want the trustee services, girl. Where you go? Can I get services? Yeah, it's like y'all give everybody else services. Y'all won't ever take services from me. Why? Why? Shit is not fair, man. Shit is not fair. Hey, y'all, that shit is not fair what they doing to me, man. I can't even get I can't get services. They'll sell to y'all all day. I can't get no goddamn services. That's crazy. Why can't I get services? Why? Why can't I get services? Huh? Sean, you read the IRS website? Okay. Sean, you gotta learn IRS language. You gotta learn IRS language. You gotta learn IRS language. The IRS language, the IRS website. Yeah, you might have to get a consultation with me, bro. I can show you about 50 contradictions with the IRS says on their websites and how they actually do it. I can show you about 50. Mindset, Sean. You have to have the mindset, like, because we look at these establishments like big bad wolves. So whatever they say, it must be it. And that's how they get you. They throw it out there and tell you that, so you stay right there and move off that. Yeah, Sean, book a consultation. I think you need one. I can show you multitudes of court cases that they put on their website versus what they actually do. Remember, it's, what can I use? Let me use these two. All right, these two. The IRS that was presented on the website, the little pamphlets they give you and all that, this version of the IRS, then this version of the IRS, what they actually do. You got to be able to see which one is which. This one right here is like this. There's nothing to see here, y'all. Just follow this. Follow this. Just follow this. Whatever this says, don't take your eyes off it. While here, this is what they're really doing. This is the real deal. So it got you like this. Follow the blue one, y'all. Follow the blue one. Follow the blue one. Don't see what we doing here. Don't see what we doing here. Just follow the blue one. Follow the blue one. That's the IRS for you. Sean, all these questions, they'll probably get answered more in the super chat. Or remember, I'm enforcing those question rules strictly. Members' questions get answered. If you're not a member, super chat. Said they are hidden students. Learning from the teachers. Teacher. Yes, I ain't ignoring your question. Cause members get first dibs on the questions. They ain't got no questions first. They might double back to your question. But the answer to that, Sean, is you'll run across it. The same way I found out, I believe you'll run across the same answer. I think you will run across the same text, the same wording that when I put it out there, I think you will run across it too. Do your vigorous study and research of the IRS system in its entirety. I think from the beginning to present day, I think you will find the same answer. I think one day you're going to be like, wow, new culture, you was right. I read it. It said the same thing. I believe one day, Sean, you will come back to me with that. I have no doubt in my mind. Needs to stick to court, not securities and accounting, of course. Now, if he's been vigorously putting the time and research in and got corporate professionals to consult with, then yeah. But we all know more than likely because everything else is running dry. Yeah, they be talking about the same shit for years. It's the same shit. Nobody want to keep talking about courtroom settings when nobody getting big relief from it. I'm new. I bring life back to this space with these new topics. I bring life back to these spaces. If I was just still talking about the same old 1099A, same old YD, same old setup, I'll be just like the rest of them. I'll be just like the rest of them. I would be just like the rest of them. This is the difference between me and them. My separation on topics and knowledge is like everybody, they're here. I'm here. Want to know why? Because I put the time and years in before I came to YouTube. Most people start a YouTube channel fresh out of attending a webinar that they paid $750 for. And a lot of them be like, okay, I'm gonna resell this webinar so I can make my money back and make more money. A lot of people's channels are birthed coming from a group, coming from another person. 2 weeks ago, they're a student. 2 weeks later now, they're a teacher. But if you ask them, well, how long you been studying and researching? How long you been studying, researching the right things? How long have you been studying and researching from a professional corporate regulation statute, acts of Congress, standards, codifications, or all the federal top level corporate like studying? How long have you been studying in that realm? Because you could be studying for 20 years the wrong thing. How long have you been studying in that realm? I guarantee you it's 0 to no years. Most people just want clicks. Most people just want to feel important. Most people want to feel praised. And it's not like people are calling their phone every day before they make life-changing decisions. It's not like they just got clients and people just calling their phone before they make life-changing decisions, before they make decisions that's going to affect their financial lives. They don't really get that everyday life. I'm talking about meaningful, real, legit conversations. We're not talking about ideology process-like conversations. Those are not meaningful conversations. Those are fruitless conversations. And they want to influence people, and they want to force that influence on people. They want to force themselves to where their opinion actually matters. Because in real life, turn the cameras off, turn YouTube off. In real life, my opinion matters. My opinion holds weight to a lot of people. In real life. My opinion matters in real life. And I think they want to capture that. But to each his own, do your thing. I just think it's more about clicks, likes, shares, comments, being liked, having attention. I think it's more that has to do with that than it has to do with actually wanting to teach the people. Oh, if I get started, yo, ladies and gentlemen, before I get started, hold on. Before I get started. Before I get started. Yeah, tag your jeweler, man. Tag your jeweler. You gotta tag your jeweler, man. You can't be popping up. Tag your jeweler, man. Roger the jeweler. RTJ Jewelers, man. Tag your jeweler, man. Pop up with the card, man. Register your shit. You gotta register your shit. So you can get your lifetime warranty. Gotta get one of these, man. When you pop out with shit, you gotta get one of these, man. When you pop out with shit, you gotta get one of these, man. Don't let them get you. Get one of these shit, man. Get one of these. You gotta get these. Lifetime warranty, lifetime guarantee, certificate of authentic. Don't have that shit turning your neck now, y'all. Y'all got real diamonds. Shit that'll pass a real diamond tester. You gotta get real diamonds, man. Gotta get your certificate of, what does the hell GRA even stand for? Oh, Global Gemological Research Academy is an independent jewel institute. We specialize in identifying gemstones and jewels. We provide reliable and accurate gemstones and jewels testing service. Our quality report is certified by experienced professional gemologists. This warranty gives you specific legal rights, and you may have other rights which may vary from state. This warranty applies in the United States and may vary in other countries. Created by JAR. Limited lifetime warranty, certificate of authentic. Register your GRA purchase. Warranty. Got to get that, man. You can't pop out with this, your jewels ain't real. If you can't pass a diamond tester, shit ain't real, man. 2025, man. You gotta pop out with real shit. Gotta pop out with real shit, man. You can't pop out with real shit. Pop out. Do your thing. I have eczema. That's why I can't do it. My neck will break out. I got eczema. Y'all who suffer from eczema, know people suffer eczema. That shit have you. When that shit turn and it gets to that copper on it, y'all know if that shit turn like how it turn your wrists green and shit. Nah, my skin is too sensitive. It's gonna hell nah, I ain't fucking around. Okay. What do we have today? What do we have today? This is going to highlight the difference between claims based on the legal, and you're going to learn you're going to learn something with these court cases, y'all. You're going to learn something. It's not like you actually learn something. You actually learn something. So this is the difference between a ideology claim and a legal claim. Even in these losses, you learn what to do. That's why you got to pay attention to the court case when people lose, because you learn what to do. Remember, a wise man learns from other people's mistakes. A wise man don't really learn from their own mistakes. You learn from others' mistakes, so you don't have to go through it. You learn your lesson through their mistakes, so you always stay ahead of the curve in life. I wish I would have learned that and applied that years ago, but now that I do, life has been a whole lot better than what I used to make it. I will say that. So let's read this case, and you all give me 1 second, and we are going to pop back. Sorry, y'all. My bad about the delay. Wipe is on. She like, when you on live, you don't be wearing your wedding band. Oh shit. So I had to put the wedding band on for the wife for a second, y'all. And real diamonds. They know, real diamonds. We can't do no fake wedding bands. Don't ask how much hers costs. I'm too embarrassed to say. Embarrassed in a good way. Shit. And I probably could have got a better deal. Plaintiff Joellen Andrews, and we're going to refer to her as Andrews, filed this pro se action. Why they do things pro se? Because they know a lawyer wouldn't even take the case. Against Defendant Select Portfolio Services. I know, I'm very familiar with that company. Select Portfolio Service, I don't know how I got there with them. SPS, they'll take anything. They'll take anything. They'll take TV dinners from you. They'll take anything so they ain't got to foreclose. They'll take anything. They so low budget. They'll take anything. I told one of my clients, I'm going to send them a sweatsuit. They're like, what's the value of it? I said, it's $120. Okay, we'll apply 80 to the interest and 20 to the principal. When you're going to get it, they motherfuckers will take anything. Andrews purports to assert claims. Oh, that's not a good thing when they saying purports. That's not good. For breach of contract, fraud and deceit, deceptive trade practices, negligent misrepresentation, and usury. Remember, we was in class last night, members. Remember I said 98% of people's claims is going to be solely on the contract only and not on the real and substance of the transaction. That's why I say you're never going to know the substance and real behind the scenes transaction unless you do your vigorous research or study, or in the case of these spaces, you know someone that knows it. Those are the only two options, because there's too many moving parts and most people wouldn't even think to look in places where they would need to look in these spaces. And y'all know I'm telling the truth. Y'all know I'm telling the truth, Supreme Elite team members. Y'all know I'm telling the truth. Remember, everything is always based on the contract in these spaces. Everything is based on the contract. Everything is just a contract. They don't know nothing else but to try to invalidate the contract. Defendant submission has been reviewed and no hearing is necessary. Wow. That's not good. When they don't even have a hearing on it, that's not good. For the reasons stated below, defendant's motion to dismiss is granted. Well, there you go. Plaintiff's motion to leave to file a reply and plaintiff's motion for a hearing is denied. They didn't even give her a hearing. The court reviews the facts related to this claim in the light of most favorable to the petitioner. This case involves a residential mortgage loan in default that Accredited Home Lenders, Inc. made to plaintiff and Andrews that was serviced by defendant Select Portfolio Servicing, Inc. Her number one problem is bringing a claim against Select Portfolio. This is why people lose, y'all. I don't give a damn if Jonah Bay, I don't give a damn if Yusuf Bay, I don't give a damn. None of them bite my talking points. They don't have the understanding that I have. They don't understand from a courtroom setting, a legal, practical courtroom setting, to post-transaction. They don't know, because their courtroom teachings is all based on common law. They don't know how to maneuver through normal times, practical law. All their courtroom teaches is common law, common law, common law, common law, common law. On October 31st, 2005, plaintiff Joel Andrews, along with Wilbur Andrews Jr., purchased a residence in Maryland. In order to pay for the property, Andrews obtained a residential mortgage loan from Accredited, which was secured against the property. You see the wording on that? I call bullshit, Judge. Because the plaintiff, when she filed her claim, she never said otherwise. Right then and there, I would have hit them at the beginning, post-transaction. I would have started a bam right there, bam right there, bam right there. So the judge would have had to view the transaction based on the substantiated substance of the transaction that I just presented in the first paragraph of a claim. First paragraph. First paragraph. The judge would have shifted in his chair. In return for the loan, Andrews promised to make periodic payments of principal and interest to her lender, started at an annual interest rate of 7.49%. The interest rate is scheduled to adjust in September. SPS did not originate Andrews' loan, nor did it own it, but SPS did acquire the servicing on Andrews' loan on April 1st, 2008. Right then and there, I would have spanked them and knocked them out of this courtroom proceeding. Yo, Supreme Elite, y'all know how we do it. Y'all know how we do it. That would have never rolled with us. No. She didn't even argue that. She didn't even argue that because she didn't know how to. She didn't know. And if you don't know, the judge ain't going to say it for you. They're going to go by whatever you putting down. SPS would have never even been in a position to file a response. If you believe that I would have knocked SPS out of this courtroom proceeding, put a 1 in the chat. If you don't believe, put a 2 in the chat. SPS would have never, the first paragraph, I would have had them removed from the proceeding, and I'd have made y'all that's hiding behind, bring your asses in this courtroom. I need to talk to y'all. SPS, nah, I don't need to worry about you. You ain't nothing but a service. I ain't worried about you. Y'all, you two right there. You two entities. You right there and you right there. Bring your asses to the front. We need you. And this is what they all teach you, to invalidate the contract. You lose when you try to invalidate the contract. That's your sole position. You lose. On October 2009, so from what I'm gathering, about 4 years, a little under 4 years, she made her payments. Because I don't see anywhere from 2005 to 2009 that she has a claim in that she's making today. and she filed for bankruptcy. So there are two things. October 3rd, 2009, she filed for bankruptcy. So these claims, I think they came when she filed for bankruptcy. Which her filing for bankruptcy and making the claims that's not a part that that's normal. That's typical. She filed for bankruptcy. That's cool. But if you ask my honest opinion, she lost the case right from the beginning. She lost when she let these people. No, these people would have never even been a part of the. No, I would have invalidated them from the beginning. If you ask me, she lost her case from the beginning. 1 second, y'all. I am back. I am back. So yeah, it looks like she lost the case for me if you ask the beginning. Because I don't even know why Select Portfolio Services there. I'd make the real party come and defend against this arsenal of claims I would have put in front of them. Andrews could say that she made payments under the terms of her loan through November 2008. Andrews states that she stopped paying off her loan at that point because she contends that she believed that she no longer had a duty to make payments under the terms of the loan when the self-evident amortization schedule of the loan over the life of its payments, citing the amount of interest to be paid monthly as a part of each monthly payment, did not constitute the interest of 7.49% or any future rate calculable in the loan contract on the actual amount that would ever be at risk in the life of the loan contract. What? That is a first. What? Hold on. You stop paying your mortgage over that? Oh, Lord. There's no way. It's got to be more. It got to be more. Over that, the amount of interest monthly paid did not constitute interest of 7.49% or any future rate calculable in the loan contract. This is what I'm trying to say. Okay, if you felt like you had no duty to pay, why did you just stop? I tell y'all, they make these decisions to stop, and then when that didn't work, then she filed bankruptcy. Okay, the picture's becoming clear. When the fact that what she, I guess, communicated to them didn't work, she ran to bankruptcy as a strategy, which I get the strategy. That's what happened. She tried to stop paying her mortgage because of okay. On February 26, 2009, Andrews was dismissed from bankruptcy due to her failure to file an amended plan. The question that I have is, why, whatever. Andrew subsequently filed the subject 54-page complaint. Already got the hallmarks of a sovereign citizen more. Want to know why? That 54 complaint represents frustration. I'm mad, and I'm just going to throw everything at you. 54 pages of shit you didn't research? All copies and templates? It's one mortgage. It's not like you in a multi-billion-dollar corporate transaction. It's one mortgage, 54 pages. Y'all, when y'all put all these volumes of paperwork on the documents, they're automatically going to assume that you are a sovereign citizen, Morris American, patriot, redemptionist. Because you don't need all that paperwork for this. You can get straight to the point, 5 to 10 pages. You can get straight to the point in 5 to 10 pages. 54, you know it's just a bunch of ramblings over ideologies and theories, and they did this and they did this, and nothing substantiated. I guarantee you, nothing in that 54-page complaint was substantiated. In the Circuit Court for Frederick County, on September 17, 2009, defendant SPS filed a notice of removal to this court pursuant to 28 U.S.C. 1441A. Oh my gosh, I'm tired of this shit vibrating. Let me oh, it is. Put on silent. But her problem is she should have already filed this in the federal courts in the first place. Why she filed a 54-page complaint in the circuit court? Want to know why SPS filed the notice of removal to this court? So they can get a dismissal. So they can get a dismissal. That's all they did. They filed it just to get a dismissal. 1 second, y'all. I need some chapstick. My lips. Chappy, ashy lips. That's like, why wouldn't you, Miss Andrews, if you watching this, if you ever watch this, you need to reach out to me, because although it looks like you probably lost your house, I think there's still some business on the back end that we can conduct. I just want 70% for you putting this bullshit into the court. Because this court has original diversity jurisdiction under 28 USC 1332. Miss Andrews, you're supposed to know that. Miss Andrews is a Maryland resident. SPS is a Utah resident. And Andrew asserts an amount in controversy over 400,000. You're supposed to know this. In her opposition, Ms. Andrews claims that this court improperly granted removal in diversity jurisdiction does not exist. In support of this argument, she contends that she is not a citizen of Maryland. However, Ms. Andrews specifically states that she is a citizen of Maryland in her complaint. Yo, they be listening to these sovereign Moors, patriot teachers, and they be having these people look foolish in court. All of them looks foolish. All of them. I have not met one case where the plaintiff doesn't look foolish. They always look foolish. Accordingly, removal was proper. See Ultrasound Verse Imaging Corp. See, Miss Andrews, you were supposed to research the procedures on diversity jurisdiction and what are grounds for removal or not. You didn't research the grounds. I'm telling you, y'all, my research is impeccable in this space. I'm going to go to depths where a lot of people are too lazy to go. Explaining that plaintiff was bound by the assertions made in her complaint and that she cannot use motions and briefs to amend this complaint. You are bound by the assertions made in your complaint. This is why I say you get one shot with these people. One shot. It's not like you do it wrong in the court, they get a judgment against you, and do you try to run back? Oh, okay, I fixed it, but do it right now. No. One shot. Andrews' complaints alleges the following 9 counts. What's the first one? What do you know? What do you know? What do you know? What's the first one? What's the first one you see? What's the first one you see? Breach of contract. How breach? What, they didn't give you the house? What they didn't do in the contract? The breach of contract, that need to be like your 5th, 6th argument. That need to be at the end just to put a ribbon on it. Well, if I don't do the contract first, what am I start off with? That's why they do it, because they don't have the answer to that question. What am I start off with without the contract? If the contract ain't important, then what do I use? That's a question from a person who lacks understanding. Because in this world, this business world, these transactions, you're already supposed to know. You're already supposed to know. You're bringing a claim, right? You're already supposed to know. Fraud. Number 2. 3, deceptive trade practices. 4, negligent misrepresentations. 5, usury. 6, lack of jurisdiction and standing of defendant to enforce the rights of contract and foreclosure. Okay, I like 6. I like 6. I like 6. 6 should have been number 1 if you ask me. And it all depends on how she argued. I can already have an idea how she argued it. But I like that. Lack of jurisdiction and standing of defendant to enforce rights of contract and for. I like that. I like that. That's a good one. But I'm going to reserve if she argued it right. Number 7, breach of contract. Misrepresentations of material and fact and documents and events of the loan closing. I like that too, but it's a thin line between arguing that and the right way or the wrong way. There's no room for error in those. Number 6 and 7 are some tough, good ones, but you got to have extensive understanding to pull those 2 off. You have to. It's so easy to talk about it. Those are she's getting into deep waters with those. You're getting into sensitive topics with those. Number 8, breach of supplement provisions of a contract in law, withholding a material fact. All these, I'm not gonna lie, number 8 is good too, but it all depends how she argued it. Number 9, void and unlawful lien. I like number 9 too. But when you make a claim, whether it's in court or out of court, it all depends on if you can prove what they actually did that is premised on what they have to do, and can you explain and state your claim that there's no doubt that they did not do what you said based on your evidence. I think that is the piece that people are missing. They think that all you could do is just tell the judge they did it and then expect the judge to do the research and figure out the rest for you. You can tell the judge they did it, but you have to substantiate it with black and white, irrefutable evidence. The caveat to that is you will never find the black and white, irrefutable evidence if you don't do black and white, investigative, like extensive research. And it's not the extensive research that's the problem for a lot of people. The problem is how they look at, how they view the extensive black and white research that they have to do. They look at it as a burden, it's going to take too long, too time consuming, or they're looking at it like this is what's needed. This is going to take me to the next level. However you look at it is your own right. Instead, Ms. Andrews maintains that because lenders are only required to retain a percentage of assets and deposits under the Federal Reserve System, oh God, accredited was only actually placing at risk a small portion of the 279,922 and advance the remaining through depository institution credit. No, you are totally off. I see what you're trying to say, but you're off. No, you're off. You're her premise is that she doesn't really think that the full amount of $279,920 was not put up. That's the problem. She really thinks that the full amount was never put up. A lot of people in these spaces never really think that from the standpoint of what if the full amount for your closing costs and your mortgage was actually put up? They never look at it like that because a lot of people have been taught that it's never looked at like that. Or the promissory note is deposited into account and then they issue money from that account. But the difference between understanding is just the subtle changing of your thinking. It's like you got to change your thinking, like tweak the volume a little bit to the right, and it'll click for you. Andrew's motion to dismiss, paper number 4. Andrew's complaint is based upon an invalidated legal theory. Before I skip down, I just want to make sure. Let's get right here. A complaint must be dismissed if it does not allege enough facts to state a claim to relief that is plausible on its face. It has to be plausible on its face, like directly on its face. There is no, and this is what I'm saying. These judges make these legal determinations on its face. When you make a claim, you don't get into the full diatribe of what happened. You summarize it in your initial complaint. And then if you got to get into detail, you get into that in the later stages. But the judges determines whether they ask the other party to respond or not, whether there needs to be a hearing on it or not. Under the plausibility standard, a complaint must contain more than labels and conclusions or a formulaic recitation of the elements of a cause of action in order to survive a motion to dismiss. Thus, a court considering a motion to dismiss can choose to begin by identifying pleadings that, because there are no more than conclusions, are not entitled to the assumption of truth. This is why black and white legal facts, not what you believe is true, aka legal standard versus ideology. Well pleaded. Hold on. This is why I say what I say. They about to tell you exactly how you're supposed to do it. Damn, where the hell is that? Well pleaded factual allegations contained. Oh, hold on. Hold on one second. Jeff, you can come up and entertain us. You all right? Hold on. Jeff, you can come up and entertain us. Come on, come up and entertain us, Jeff. Come up and entertain us, Jeff. Oh, the paste button ain't working. Come and entertain us. Why this paste button ain't working? You can entertain us. Don't know what you're going to have to say that people really want to hear, but I'll get it working in a second. Jeff, you come up and entertain us. Oh, you can get that way. Like I say, y'all, this ain't meant for everybody. This I really only speaking to a select few. Select few, you know who you are. If you know I'm talking about, you put a one in the chat. Select few. Because I ain't talking about everybody that's watching. It's only a select few. Only a select few. It's only a select few I've talked to. I don't talk to everybody because I don't give a shit about everybody. Actually, it's only the people that I care about that I want, that I go into great detail with. Notice I don't go in great detail on YouTube. I don't get into detail. I would never go into detail on YouTube. Not the grave. No, fuck no. Shit. You can find the same great detail. Take the years that I did to study and research. You'll find the same shit. Not on YouTube. Well pleaded factual allegations contained in the complaint are assumed to be true, even if they are doubtful in fact. Well pleaded factual allegations. That's what a lot of them don't know how to do. Because be honest with you, y'all, new culture members, y'all know that a lot of people in these spaces, in these sectors, they think like a consumer. They act like a consumer. They live their daily lives as a consumer. And you know what we said, that what are consumers to the secondary markets, the money markets, the securities markets? They're the economic slaves. They're the engine that fuels their trillions of dollars of revenue. Consumer-like thinkers, they don't know how to leverage their assets in that world. No, they don't even have the capability to even think that far. They don't even think that far. Most of them don't even think past the day. Every day is Groundhog Day for them. But legal conclusions are entitled to judicial deference. Thus, even though Rule 8 marks a notable generous departure from the hyper-technical code pleading regimen of a prior area, it does not unlock the doors of discovery for a plaintiff armed with nothing more than conclusions, which makes up 98% of these spaces like this, That's what all their claims are. Nothing but conclusions. HJR 192, the real law around that has nothing to do with what they think from it. But what do they use it as? A fucking conclusion. It has nothing to do with what they say. HJR never said the government is going to pay your debts. HJR never said that, oh, only lawful money, gold and silver is lawful money. But guess what? That's state. The state don't make money. State don't create money. Money's created by the federal government. The states get infused with that money. Those Federal Reserve dollars, the state has, wherever you see the Commonwealth of Virginia issue its own money. When? Never. Back in the late 18th, 19th centuries. So when they say, oh, only gold and silver is lawful payment of debts, guess what? It never applied to what you was trying to get out of anyway. That's what I'm saying. Think like a consumer. Consumer-like thinking. That's a consumer-like thinking right then and there. How can you say Article 1, Section 10, when it says no state shall, and then the government has the authority to create money, to create legal tender, and you still use, hey, I can't pay my debts because lawful money, gold and silver. But they was only applied to the states, not the federal government. Consumer-like thinkers. It's a problem. Consumer-like thinking. A lot of this shit comes down to intelligence, to be honest with you. A lot of this shit comes down to intelligence. Like you got a lot of no, fuck intelligence. A lot of shit comes down to common sense. No, throw intelligence out the window. Common sense. When this space starts to bring common sense back to it, I think it would be pushed in a better direction. But this space lacks common sense through and through. Common sense. Common fucking sense. Lacks it. Through and through. No common sense. No common sense. No common sense. No common sense. Wanna know why? It don't stick for a lot of people? Because when it sticks organically. Most people are trying to force it to stick with them because they believe it's some financial obligation relief or benefit from this. You got to think how foolish you can be for someone to try to use this process, these teachers, whatever, just to get out of a bill. How foolish can you be when there's so many moving parts, so much shit you got to understand, and you think you're going to know all that in time before your foreclosure date? Bankruptcy's good. But if you don't know how to invalidate their security interest in bankruptcy, why are you going into bankruptcy? Because you know what it is? Most people, they want to keep it all and don't be responsible for none of it. Greed. It's the number one motivating factor for people to be in these spaces today is greed. It's the number one motivating factor. Do you really think they really want to take the time out and research and study? Like, fuck no. Hell no. They don't. Why? Because consumers don't do that. Consumers don't do that. They just consume and go with the flow. I'm talking about consumer up here. Consumer-like thinking. No, in the securities world, they're called the economic slaves. I don't take that position personally, but that's what they refer to. The EECs or the slaves. The ES. Y'all would just get the ES to do it. No, when they talk, that's how they talk about it. But we'll get the ES to do it. We'll pass it on to the ES. Call them economic slaves. The government, they figured out, why have one race of people continue to be physical slaves? And that's where the powerful bankers, international, the Rothschilds, all that's error. They were like, why have one race of people become the slaves when we can have everybody enslaved economically? And they was like, you know what, that's a good idea. It's like, fuck slavery as a race. We gonna get everybody. And that's what they did. Yeah, fuck it, we gonna get everybody. The vapor money theory states that any debt based upon a loan of credit rather than legal tender is unenforceable. And if you look on TikTok today, you got everybody saying they can't loan credit, they can only loan money. Which is true. I can give you that. I could point to statutes that says, court cases that says it. But when I revise those court cases and I look back at them again, I noticed that a lot of these court cases were pre 1933. A lot of these were around the common law times, the barter exchange times. So when I seen that, I said, they switched the game after these court. You talking about a court case from 1864, 1879. I said, that fucking court ruling won't survive today. They done rechanged the game so many times afterwards. Johnson versus Deutsche Bank. This theory has been consistently rejected by federal courts as frivolous and insufficient to withstand a motion to dismiss. And if you go to the case of Richardson versus Deutsche Bank, holding that the vapor money theory is patently frivolous and a waste of judicial resources. And I know exactly why the judges say that. They know why. I know why they say it. I know why the judges say it. It's evidence in our research why they say it. Because there's no such thing as a vapor money when somebody's actually putting up the money. That's what I say about these spaces. They never, ever contemplate to even fathom the fact that somebody actually put the money up, because everything is supposed to be tied to this secret, non-existent account that they don't even understand or know how to locate it. Legal standard versus ideology. That's why I say what I say. All right. Andrews' claims in counts 1 through 5, 7, and 8 are all based on the allegations that a creditor did not risk its own or depositor's assets when it lent her $279,920 to purchase her home in October 2005, but instead only actually put at risk $8,397.60. Andrews explains that this smaller amount was the cash reserve requirement ratio fractional reserve percentage of a credit's assets and deposits required to be held and actually placed at risk of the actual face principal of the loan in accordance with the requirements of the Federal Reserve System. I understand that argument. I definitely understand that argument. But that is not an argument you have in the court. I really don't think that argument. Remember when I say, even sometimes when you know some things may be true, you just can't bring them up, because look, if the judge would have granted her, look at this. If the judge would have granted her this, all everybody got to do is look at this paragraph right here and be like, well, if that's for her, that's for me. what they do is they make their claims, although she's keeping it singular to her own. She doesn't understand she's creating a national security risk with that claim. And even if that was the case, that has nothing to do with her situation. It has nothing to do with it by the bank's reserves. It has nothing to do with it. That that doesn't determine how much she has to pay back. Because although she thinks that $8,397.60 had to be held in reserves to cover it, the part that she don't understand is someone actually put up the 297,000 up. She really doesn't think that happened. She really doesn't think that happened. She really doesn't think somebody put up that amount of money. That's the biggest problem. She don't think it was put up. And a lot of teachers never told you that somebody put the money up but me. So when y'all hear them saying, oh, somebody put the money up, they got it from me. Once again, I'm your teacher's teacher for a reason. Andrews explained, oh, okay, go. Thus, Andrews, according to Andrews, accredited risk $8,397.60 of its own assets, and the remaining $272,522.40 was free credit from the Federal Reserve. I told you, they think everything comes from the Federal Reserve. They think every fucking loan, every money for you to close, they think it all just goes to the Federal Reserve. And even when they do go to the Federal Reserve, they're not going to the Federal Reserve for you to close. They're going to the Federal Reserve so they can benefit from the spread. When they go to the Federal Reserve, they're trying to go to the Federal Reserve to get a 2-for-1. Get a loan on the same amounts that you're already paying and benefit from the interest spread. So if you're paying 12% interest, they only got to pay 4% interest. They benefit from the 8% spread. Remember, when they go to the Federal Reserve to get a loan or an advance based on your mortgage, remember, your transactions already closed. Money has already been paid. Her and a lot of people that have this patriot, sovereign citizen, Moorish American-like thinking, they think your transaction closes when the Federal Reserve sends the money. Whole time, that's not how it works. 98.99% of cases, it don't work like that. Because most banks today have access to credit lines, got access to the markets. And this is the problem where people only study from this revisionist history standpoint and don't study from the general system in its entirety. They don't understand the markets. If you don't understand the markets, you will never understand the banks. You never understand how it really works. They don't understand. All this is sovereign citizen bullshit. That's all it is. It's the same shit over and over. Count 69 Andrews attempts to state a claim for fraud by alleging that a creditor made misrepresentations by not informing her that her lender was loaning her credit and not hard money. Who gives a rat's ass if they loaned you a squirrel? You agreed to pay it back. You could have contested the contract at closing. That's how they look at it. And it doesn't matter if it's credit or legal money, whatever. It's just as good. You're not going to win that argument in no federal court. But welcome to the sovereign citizen, more patriot community where dying on hills that aren't worth dying on is a requirement. Although Andrews contend that she has not espoused the vapor money theory as the basis of her claims, All of her claims all plainly rely upon the very essence of the vapor money theory. So yeah, she think this is not a vapor money. They're like, yes, it is. Oh, it very much is. Since that legal theory is invalid, Andrew's complaint must be dismissed. And I understand exactly what she was trying to do and mean by the reserves. I understand. I understand what she was saying, but that is nowhere near an argument for court. That's not an argument for court. People always want to put the most controversial claims in their court case because they so goddamn desperate of their situation. They'll blow the whole. They will put claims out there where even if the judge wanted to give them a claim, they couldn't give them the claim based on the claims how it's being presented. Like they would not. People, you could tell when you're in the patriot, sovereign, more like community, you'll put out claims that are solely based on national issues that will affect every other fucking borough in the world. That's when you know you got a patriot-like movement, sovereign, more like movement claim. When it's so like, what the fuck, that you kind of expect the judge not to give them remedy. If the judge gave you remedy, it's going to collapse the system. That's what they got. That's what they put out. They put out claims that if it gets granted, it'll collapse the system. When you see those types of claims, Moorish American, sovereign citizen, patriot, redemption theory. That's all they do. Because they're so narrow-minded in their own dilemma that they're not sitting back and look, well, hold on. If the judge gives me remedy on this, then they got to give everybody remedy on this. And then nobody would pay for their mortgages. There'll be no need for, like, come on, man. It's just, but when you think like a consumer, you don't think like that. When you think like a creditor, you're looking at all potential risks. Consumers don't think like that. Consumers just think for the moment. Even if the vapor money theory did provide a legal basis for Andrews' claims, Andrews failed to provide any factual allegation to support her claim against SPS. But when I say you got to have black and white facts, data, statistics, people look at that as, oh, it's going to take me more time. It's an inconvenience for them. They just want to hear them get their claim in. Did she substantiate it? All she did was just say this happened. What did she use to substantiate that claim? What did she use to substantiate the claim? Not a goddamn thing. Want to know why? Because none of them do. They never do. Andrews fails to provide, as Supreme Court explained in Ashcroft versus Iqbal. Iqbal. Claims has facial plausibility when a plaintiff pleads factual content that allows the court to draw the reasonable inference that the defendant is liable for the misconduct alleged. Supreme Elite Team, y'all, imagine that, looking at that, and imagine how one of our court motions would look. I be wanting to read some of my statements and stuff off on here live, but I already know. I already know. You're going to have to teach them. I got statements for sale next week. All they do is bite. They don't do no research or study. All they do is bite. That's all they do, y'all, is bite. That's all they do is bite. When people talk about the March 9th, 1933 remedy, They don't even understand what the real remedy of that is. I'm not talking about all the emergency provisions. I'm talking about the statute itself. They don't even understand the real remedy. They'll quote it. Page 83, paragraph 2, expansion of currency necessary under the new law. The money is issued in the bank, backed by the creditor. And they don't even understand what that really means. In this case, Andrews' claims against SPS are based upon the unsupported assumption that SPS is responsible for accredited's actions because it is accredited's predecessor. However, Andrew never explains how SPS is responsible for accredited's actions, which, if that was me, that would have been in the original claim. I would have enjoined them. Well, I'm talking about her. Me personally, I would have invalidated SPS. They wouldn't even have standing in the. Nah, I'd have validated that on black and white factual evidence. Instead, Andrews concedes that credited originated her loan and that SPS cannot foreclose on her loan from accredited because SPS has not been established as the legal holder of the debt. That was the perfect time to explain why. You know, hey, look, you notice how the judge ain't say nothing about that. Notice how the judge said, nah, even if she did, she still wouldn't have been. Look how he said, furthermore, so notice how the judge said, well, she would have had a claim here, so let's just move on. Notice, prime example. Let me show you an example. When it says, in this case, Andrews claims that SPS are based upon the unsupported assumption that SPS is responsible for accredited's actions because it is accredited's predecessor. However, Andrews never explains how SPS is responsible for accredited's actions. You see what I'm saying? You see what I'm saying? They left room there for it. Instead, Andrews concedes that accredited originated her loan and that SPS cannot foreclose on their loan from accredited because SPS has not been established as the legal holder of the debt. You notice how they just move right on. Furthermore, because I know the judge know. Oh, you had him if you would have explained it. Remember? See? Never explained. First, then when they say, hold on, you're not the legal holder, you just a servicer. Furthermore, see how they just moved on? They know she had him right there. She had him. There's like 2 instances where she had a little bit. But the problem is, every point that she's really making, that's making a real point, she didn't even realize it's a point she's making. She's so caught up on the vapor money theory that everything that she was focused on had no goddamn merits. All the other little secondary stuff she was putting in had more merits than the stuff she was focusing on. I could see it. I could read it and see. Oh, that was a perfect opportunity right there. This shit gets sad at some point. And I ain't got no dog in the fight. But it's like, God damn, you was in the perfect. She don't even realize the perfect position she was in. Furthermore, in her opposition, Andrew states that she brought suit against SPS because it has been impossible to tell who is the party to sue here. No, it's not. It's real easy. It's real easy. It's not. Supreme Elite Team, put a one in the chat if we have identified all parties to a mortgage, auto, credit card transaction. Put a one in the chat if we have identified them all and know their positions. Because that's what the judge gonna say. No, it ain't. That's what the judge gonna say. No, it ain't. Exactly what the judge gonna say. Judge gonna say, no, it ain't. You just ain't do your research. No, it ain't. It ain't hard to identify them. Matter of fact, it's very easy to identify them. It's not hard. It all depends on how it all depends on how you want to how far are you going to go? That's what it boils down to. How far are you going to go? How far are you going to go? What do you say? The more qualifiers I have, the less you have. In the everyday to the everyday. Oh yeah, in the League of Legends. They don't even want to pay for your legal fees. Yeah. The more qualifiers I have, the less you have. Academic arguments typically about probability and possibility, not certainty. And therefore, uses a lot of qualifiers, such as many, some, fewer, one. I can get that. The more qualifiers I have, the less you. Yeah, I agree. Andrew Lewis, oh, Adam Lewis, I agree. And the everyday, yeah, the Legends of League of Legends. They don't even want to pay for your legal fees. No, they don't. Oh, they stingy now. But Adam, yeah, I can, yeah, I agree. I agree with that terminology. Yeah, probability and possibility. Yep, that because that's exactly how I can identify with that statement. Yep, not certainty. Yep, that's exactly how qualifies. Yep, the more qualifiers I have, the less you have. That's a fact. That's a fact. That's a fact. Yeah, famous nobody, another one in court. That's a fact. That's a fact. Actually, that is a good point. I'll be honest with you. That is a hell of a point. The more qualifiers I have, the less you have. That is a very good point. That is a hell of a point. Yeah, I agree 1001%. The more you can, the more your shit qualifies, the less they have. That's a fact. That's an absolute fact. And that's what that's the name of it. Invalidating their argument while substantiating my argument at the same time. That's pretty much what it boils down to. If my argument is substantiated, then your argument you don't have much to come back on. It's all about who has the best substantiated argument. That's what it boils down to. Like you said, probability and possibility. That's all it is. That's all it is. It's not really so much about what actually happened. That's not even the main point. The main point of uh, a coherent legal argument is that the facts and evidence and claims that you state are factual and meets the court's legal requirement for relief. That's it. That's it. Let me put all these facts and claims within the court's legal requirements. That's it. That's why they say claim has facial plausibility when the plaintiff pleads factual content that allows the court to draw the reasonable inference that the defendant is liable for the misconduct alleged. That shit like that. That's what I'm talking about, like that. Pleads factual content that allows the court to draw the reasonable inference that the defendant is liable for the misconduct alleged. And when we go and say the more qualifiers I have, the less you have. And we take that statement from Adam Luis. That's a good one, Adam Luis. When we take that statement, so when we say the more qualifiers I have by result, by operation of law, you're going to have less qualifiers. So the more qualifiers that I have, this allows the court to draw the reasonable inference that I have more qualifiers than you. And if you have less qualifiers than me, then that means you are potentially liable for the misconduct alleged. See how we tied that together? See how this is called intellectual thinking.
You're rocking with the best.
This is intellectual thinking.
You're rocking with the best. We're about to take it back.
That's intellectual thinking. Because it's never about whether you're guilty or not. Is everything about my qualifiers more than yours. When we put all that together, and what it really boils down to is, are you painting the most clear picture for the court? Are you painting the clear picture for the court? That's it. Who paints the best picture? And the more details you have in your picture, the less details they're going to be able to put in their picture. Goes back to the more qualifiers I have, the less qualifiers you have. Adam, that was a hell of a analogy. That was a hell of an analogy. However, Andrews never explains qualifiers, how SPS is responsible for accredited actions. That's a qualifier. That's a qualifier. Because if you can substantiate how they're responsible, I'm just going by, I would have never put it like that. I'm just going by what she put. If you can substantiate how they're responsible, then the chances of them sufficiently substantiating how they're not responsible is less, which goes back to his original point. It's about probability and possibility. In academics, yes. When I was in school for business management and applied science, we applied science to a lot of our business models, our mock business scenarios. We did apply science when I was in college for a little bit, for the time I was there. Yes. I didn't make it through my first year, but my first, I think it was 3 semesters, 2.5 semesters, I had all A's and B's. I be in the neighborhood with the guys, like, where you going? I was like, shit, I got homework. I know you a corporate thug. For real, I was like, shit, I got homework, nigga. Y'all tripping. And for real, it's like, yeah, nigga, I'm in college. They say, nigga, stop playing. You ain't in no fucking college. Say, I am. Dead serious. I am. I'm in college, bro. You know, yeah, that's what's up. But yeah, I was at ITT Tech, 2011. Yeah, I definitely got college under my belt. I got the Pell Grant from Obama. You know, them books is like $500, $230, $330, and that shit, yo, shit. So the whole business, not always pro, like, you know, it's always pro from a professional standpoint, business. I mean, I don't know how to approach it any other way from a legal standpoint. And then when I was in school, the professor used to drill us on the regulations, business regulations. Make sure you're compliant with the right. So that transpired over here. Like everything is like business regulations, business. Furthermore, in her opposition, okay, parties are not generally permitted to file a surreply. A party moving for a lead to file a surreply must show a need for a surreply. If a defendant does not raise new legal issues or new theories in its reply brief, there is no basis to permit a plaintiff to file a surreply. So basically, what that's saying is they would have to find a brand new unrelated issue. That's what I think. Andrews explains her motion for lead to file a surreply that she would like further briefing because SPS replies goes into greater detail in its arguments for dismissal on certain points than was required of plaintiff to defend against previous to this. However, Andrews does not specify what you have to be detailed. I tell you, when they respond like that, when they say, however, Andrews does not specify what details or arguments require further briefing. They're basically saying you have a point. You have a point. That's what they're saying. You have a point. They're saying you have a point, but you're not getting into detail. This is why what the court was saying, a lot of people just think they could just make conclusions and just statements or just allegations, and that is enough. She needed to say, on this, they went more into this, so I need to reply back to that, because if you look at here, the responses was only limited here. But if you see here, they went into detail, see paragraph this, always trying to see this. See, they don't know how to put in the legal form. They don't. I see what she was saying. If I was typing this up I would have used maybe like 2 of her arguments, how she did it, 2, and we would have came up with another whole game plan. Furthermore, SPS reply brief raises no legal issues and argues no new legal theories. Accordingly, her motion was denied. For the reasons stated above, defendant's motion to dismiss is granted and plaintiff's motion for leave for surreply is denied. Once again, denied. On December 25th, hold on. Rhonda Lynette Short Evans, Beneficial Financing, Inc. And this is 2015. On December 27, 2005, plaintiff obtained a home mortgage refinance loan from Beneficial Mortgage Company of Maryland in the amount of $393,997.28. secured by deed of trust against property located at Crasher Place, Upper Marlboro, Maryland. I know exactly where that's at. That's crazy. I know exactly where that's at. So when they say secured by deed of trust, they think that in exchange for the loan, you get a deed of trust. It's not what it means. It's not what it means. A deed of trust is never issued or granted in exchange for a loan. Never. From an accounting standpoint, it never is. The loan was used to satisfy a pre-existing mortgage loan on the property. A certificate of satisfaction for the pre-existing loan was recorded on February 16, 2006. Plaintiff defaulted on the loan on December 16, 2013. So, from 2006 to 2013, there were no claims that she raised in this case. One of the major things that I look at is the timing of these claims. What's up, y'all? It's always the timing of these claims that I look at first. That really tells me what classification I'm gonna put you in. Beneficial initiated foreclosure action against plaintiff in the court for Prince George's County. I know exactly where that's at. Yeah, PG County. Plaintiff entered the original loan agreement with Beneficial Mortgage Company in Maryland. The parties agreed that Beneficial Financial Inc. is the successor in interest to Beneficial Mortgage Company of Maryland by way of merger. Plaintiff attaches an exhibit to her complaint, the December 27th, 2005 loan agreement, but not the deed of trust. In her complaint, however, plaintiff asserts that the deed of trust is recorded in the land records of Prince George's County, Maryland. Defendant attaches the copies of the deed of trust on exhibit in its motion to dismiss, and it may be considered because this is a matter of public records and is incorporated by reference in the complaint. MERS. They're talking about that good old MERS system. All the MERS foreclosures were invalidated. MERS, you're just a nominee. You ain't the fucking beneficial owner. You don't hold a beneficial interest. You were just a nominee. So it's unlawful for you to commence foreclosure when you have no economic interest in the payments or nothing. You're just a nominee. And they knew that from the beginning. But it wasn't to the wasn't to the mortgage crisis when it was like, oh man, y'all wrong. Y'all know they've been wrong. A nominee cannot foreclose. Plaintiff states in her complaint that her former husband's signature was on a deed of trust, but he has been quit claim deeded off the deed of trust. On December 20, 2013, Beneficial sold plaintiff's loan to LSFH Master Participation Trust. Hold on, when did they file the December 16th? Hold on, this don't make sense. This don't make sense. So you defaulted on the loan, and on December 16, 2013, Beneficial initiated foreclosure action against plaintiff. But then you say on December 20th, 2013, Beneficial sold you sold a defaulted loan? Stop playing. Stop playing. Like, are you really serious? Lady, you didn't. Oh, God. A notice of sale of ownership of mortgage loan dated January 9th, 2014 was sent to plaintiff, informing her that the loan was sold to LSFH, Master Participation Trust, and that Caliber Home Loans, Inc. became the new loan servicer. But plaintiff defaulted on the loan December 16th and you initiated foreclosure. Something happened where they stopped foreclosure. Because they skipped down to, on January 16th, 2014, Beneficial mailed plaintiff its own notice, informing her to send Caliber all payments due on or after February 1st. On February 12th, Caliber sent a letter to plaintiff titled Important Information Regarding Your Servicing of Your Mortgage Loan. The letter confirmed that the servicing of plaintiff's mortgage loan was transferred from Beneficial to Caliber as of February 1st, 2014. Plaintiff began sending mortgage loan payments to Caliber. On February 18, 2014, Caliber sent a letter to plaintiff informing her that as of February 13, she had an outstanding debt of $555,013.76 on her mortgage. I see why they come to these spaces. They look at that debt and be like, oh God, somebody help me. They look at that debt and be like, I need help. But the original was $393,000. Oh, that's the yeah, okay, I see. On May, February. So this was February 1st. February 18th. So from February 18th to May, I don't believe a payment was made. And this is probably due to somebody. It's probably due to somebody telling her she didn't have to pay. It's probably somebody telling her that she didn't have to pay. And I think so. Because on May 7, 2014, plaintiff filed a complaint in the District Court of Maryland, naming defendant Fisher Law Group. I know Fisher. Fishe. I heard of Fisher. Caliber Home Loans, Inc. and Beneficial. Plaintiff asserted breach of contract and fraudulent misrepresentation claims against Beneficial. Plaintiff further alleged that Caliber and Fisher each violated the Fair Debt Collecting Practices Act. Why do y'all keep going to? I mean, that's good, but why don't y'all hit them with the meat and potatoes? On June 20, 2014, the three defendants jointly filed a notice removing citing diversity jurisdiction. Why are they filing these court cases in a state case knowing the federal courts got jurisdiction over these claims? Defendants Caliber and Fisher each answered the complaint. Beneficial moved to dismiss the complaint on July 25, 2014, which the advisor of the pendency of the motion to dismiss and her entitlement to respond within 17 days from the date of the letter. On September 22nd, 2014, plaintiff moved for leave. Do you notice right here when they say advised her of her entitlement to respond, they got a court case regarding just responding for a motion for summary judgment? You notice that they even got that. The courts do the best research. Plaintiff filed a response to Caliber answer. On September 22nd, 2014, plaintiff moved for leave to amend her complaint. Beneficial opposed the motion to amend, and the plaintiff replied. Beneficial argues that plaintiff's breach of contract and fraudulent misrepresentation claims are barred by Maryland's 3-year statute of limitations for common law claims. Let me just get down. A plaintiff is under no obligation to plead facts in his complaint to show the timeliness of her claims. The burden is on the party asserting the defense to plead and prove it. Okay, look like she okay. Like she made guys okay. Hold on. Plaintiff asserts that in the complaint that Beneficial breached the December 27, 2005 loan agreement and made fraudulent representations in connection with the loan agreement. Beneficial argues that the loan agreement was executed on December 27, 2005. Thus, plaintiff had until December 27, 2008 to file a breach of contract and fraudulent misrepresentation claims within the manor's 3-year statute of limitations. Why didn't the defendant Beneficial state that her claims lacked merit? And here these court cases, Judge, that's saying all claims similar to hers have been rejected in the past. Why did they only try to use the stat? I told you, when these banks and these lawyers cannot win on factual evidence, the factual cases, when they can't win on the black and white evidence, they will always try to get you barred by procedural mistakes. It never fails. When they don't win the facts, they always try to bar you procedurally. It never fails. That's when you kind of got them on the rope. So as far as what I'm reading right now, the plaintiff has the banks on the ropes. Plaintiff responds that her argument with Beneficial constitutes a specialty under Maryland law, and therefore a 12-year statute of limitation applies to her breach of contract and fraud claims under Maryland Code. Good comeback. That's a hell of a comeback. Shit. Like she been doing a little research. All right, girl. All right, there you go. Shit. About time. About time we get some actual real claims coming through the door. It's about time. I ain't mad at you. Tupac, I ain't mad at you. In Maryland, the default statute of limitation for civil action is 3 years, unless another provision of the code provides a different period of time. So the code she cited, CJ 5-102A, provides for a 12-year statute of limitations in regard to actions on specialties, including promissory notes and contracts under seal. Ooh, that was a good one. A specialty is a well-known term in common law in which Maryland and elsewhere by judicial decisions denotes a legal instrument under seal. Oh, that's a good one to hit him with the special decial. Hit him with the special decial. Hit him with the special decial, girl. I think she backdoored him with the no looker McGrooker. Plaintiff attaches an exhibit to her complaint, the December 27, 2005 loan agreement. Oh, fuck. Which does not appear to contain a seal. Let's just read. The deed of trust securing the loan agreement is notarized and sealed in 5 different places. However, thus, the deed of trust may qualify as a specialty under Maryland law. Plaintiff states in her complaint that beneficial never perfected his security interest. That's a good argument depending on how you argue it. That's a good start. It depends on how you explain how. I'm scared to read because I want her to win. I'm scared. I hope you argued it the correct way. Plaintiff's mortgage because it never. She was going to win this case. She was on track to win this case. But the fucking sovereign, she got bit by the sovereign bug. She got bit by the sovereign bug. She got bit by the goddamn sovereign bug. Because I already know what it's about to read. The goddamn sovereign bug, man. I swear, man, it encapsulates a lot of minds. Did I just use the $500 word? It does, man. It does. It encapsulates a lot of minds, man. You know what's so crazy? I didn't even know that was a word. I had to look it up. I swear to God, I never looked at that word before. Encapsulate is an actual real word. Means to enclose something in or as if in a capsule. Refers to the act of expressing or summarizing something concisely. Her speech, she encapsulated the main points of decision. I've never used that word. I've never looked up that word a day in my life. I don't know why it popped in my mind. Probably seen it somewhere and it got stuck in my subconscious, man. I've never used that word a day in my life. Encapsulate. But this was she messed up because it never loaned funds, but instead exchanged the loan for a check, which can be redeemed for Federal Reserve bank notes. Just when I thought I found one, how foolish of me, knowing the sovereign citizen bug is an infectious parasite. God damn it. She further contends that beneficial knew it was not going to credit or loan any funds, but instead exchanged the loan agreement for the cash received from the note being pledged at the Federal Reserve. Yo, she don't even realize how close she was to winning. She don't even realize how close she was to winning. But everybody thinks the Federal Reserve is. Everybody thinks the Federal Reserve is the landing port for every single mortgage, credit card, auto transaction. Ladies and gentlemen, if you walk around with that belief system, you are going to lose 10 times out of 10. It's not real. It doesn't apply to everyday situations, and it applies for certain banks who need short term liquidity within 24 hours. But think about it. This is what I want you to understand. Even when they get the loan from the Federal Reserve, it's not for you to close in that aspect in today's world. You have already closed. This is for another reason why they need the money, not for you to get your money. Thus, plaintiff believes that beneficial did not fulfill the loan agreement. Although not entirely clear from the allegations in the complaint, plaintiff's claims must be grounded on the loan agreement with beneficial pertaining to the mortgage on the property and the deed of trust securing the loan. Thus, a 12-year statute of limitations may apply to plaintiff's claim, and it is not apparent from the face of the complaint that her claims are time barred. Indeed, in its reply memorandum, defendant does not respond to the plaintiff's argument regarding the application of a 12-year statute of limitations to her claims. That's the acquiescence. So if you made a claim like that, they say 3 years, you say 12, and then they don't, then you put in your brief and they don't respond, that's an acquiescence. If the prosecutor don't say nothing, or I mean the other attorney don't say nothing, then the judge more likely gonna let it ride. So you had them right there. You had them, but you had to bring in the same old talking sovereign patriot more standpoint of the promissory note is getting deposited with the Federal Reserve, then the Federal Reserve is sending the money so you can close. It doesn't happen like that, y'all. It doesn't. And this is where legal standard versus belief system. As will be seen, however, plaintiff's claims against beneficial do not survive dismissal because they failed to state a claim for breach of contract and fraudulent mismanagement. Exactly. You fucked yourself up with that Federal Reserve shit. You almost had them too. It's sad, man. Defendant argues that plaintiffs failed to state a claim for breach of contract and fraudulent misrepresentations. The purpose of a motion to dismiss under Rule 12b-6 is to test the sufficiency of the complaint. A plaintiff's complaint need only satisfy the standard of Rule 8a, which requires a short and plain statement of the claim showing that the pleader is entitled to relief. But it still requires a showing rather than a blanket assertion of entitlement of relief. Want to know why it was that? Because even if her Federal Reserve claim, right, she never explained why. She never explained how. She never asked for certain documents to be produced, the production of certain documents that would substantiate her claim, which they're in the possession of. She never did that. So every time I see people who make those claims and never substantiate it, it lets me know that she was online, went to a class, found some sovereign teacher, and got that information from them. Because if she would have looked at the banks and their transactions, how they work, she would have never found that. So that lets me know that wasn't her own doing. That was her, just like hundreds of thousands of other people. It reversed back to the same old script. It's her following the sovereign script. Plaintiff contends that beneficial did not actually have the funds on hand to lend the plaintiff, but instead created the money by taking plaintiff's loan agreement and pledging that agreement with the Federal Reserve in exchange for a loan to beneficial. That is far from the truth. I've never wondered why so many people rely on that position when it's been routinely rejected and it's not how it really goes. That's what I'm saying. Ideology versus legal claims. This is a sickness. The sovereign citizen community, the Moor community, the patriot community, the redemption community is a sickness. If you subscribe to it, you have a sickness that you need help from. I could see if this is on a $200 bill that they're taking to court on. You want to try this? They're putting this shit on their homes. They're putting these claims on with their homes. With their homes, their most important asset that they may own in their lifetime, on their homes, on their vehicles, their mode of transportations. They don't care what they just. But I'm supposed to be like, all right, y'all. So everybody you got done wrong, just come in for free. I'm just gonna fix all your mistakes for free because you already spent your money with them, and I have a heart and I have compassion. So I'm just come get it all for free. That's what they really want. No, absolutely no. If you want me to tell you everything's gonna be okay when it's really not, pay me for a consultation. I'll send the whole hour telling you. You just gotta give them time. They're gonna process your discharge and bond. Shit. Okay, so let me get down. Plaintiff's breach of contract claim is premised on what is known as the, once again, vapor money theory. The vapor money theory states that any debt based upon a loan or credit rather than legal tender is unenforceable. Plaintiff alleges that the promissory note he executed is the equivalent of money that he gave to the bank. He contends that the lender took his money, promissory note, and deposited into its own account. That's when the sovereign citizen, that's the redemption manual 2.0. That's a redemption manual type. They are so far and lost. Like they don't even realize they put this claim in back then, and this claim was rejected about 10, 15 years before they even put that claim in. That's not how it works. It's not how it works. Plaintiff alleges that the promissory note executed is the equivalent of money that he gave to the bank. He contends that the lender took his money, the promissory note, and deposited into its own account without his permission, listed it as an asset on his. That's the black and white talking point. No, he brought this packet from somebody. No, I've seen that. I've seen that exact language. I've seen that exact same language in a document. I've seen it. Let me see if I can. Hold on, y'all. Let me see if I can pull it up. Hold on. Hold on, y'all. Hold on, let me see. See, hold on, hold on. This is why. Look, look. You could pull up. It's gonna say that they all say the same shit. Banks don't lend you money. You loan them credit, property, aka promissory notes. About teachers' money, dealing with loans. You lend them your note, which creates the money, the actual debt at the end of the day. They shouldn't owe you money when their statements be erroneous, billing errors. Remember, Tamika was teaching the billing error? That's all they do is run around and get a whole bunch of old shit. Banks cannot loan their own money. They never loan you their own money when they give you a loan anyway, so it don't matter. They have authorized how the markets are. It's already good. They're allowed to do it. The loan number 4, the loan contract is asset deposited with the bank by the borrower. Fails to get receipt for the borrower. No money is created. No new money is created on the books. Credit against the borrower's asset. Banks fails to disclose to the borrower that the borrower's signature created new money. It's the same shit. The same shit. Look at all this shit. It's the same fucking shit. They all do the same shit. Look at these court cases. Stokes versus Wells Fargo. Look another one where it's Wells Fargo. It's the same shit. It's the same shit. Look, it's all on the internet. All you can do is just type it in. Banks don't loan you money. They take your money, deposit to an account, loan it back out to you. Banks don't loan you money. Take your money, deposit to an account, loan it back out to you. Banks don't take your money, loan you money. They take your money, deposit to an account, loan it back out to you. Banks don't loan you money. They take your money, your promissory note, deposit to an account, loan it back out to you. Banks don't loan you money. They take your promissory note, deposit to an account, loan it back out to you. Banks don't loan you money. They take your promissory note, deposit to an account, loan it back out to you. Banks don't loan. It's the same old, same old, same old. God damn. This is straight. I read this is from a document for like 2003. I read. In this case, it's 2014. Look, I read this shit in a document. This shit was in a document before. I said, this shit sound crazy. He contends that the lender took his money, the promissory note, deposited into its own account without his permission, listed it as an asset on his ledger, and then essentially lent his own money back to him. He further argued that because the lender was never at risk and provided no consideration, the promissory note is void ab initio. How did I know that? Never seen that term before. And defendant's attempts to foreclose on the mortgage are therefore unlawful. Claims based on the vapor money theory have been consistently rejected by federal courts as frivolous and insufficient to withstand a motion to dismiss, and they're going to respond the same way every time. Plaintiff's only basis for arguing that beneficial breach of contract deals with the vapor money theory. Plaintiff does not allege that beneficial failed to provide a credit line as part of the loan agreement, nor does she, I kept saying he, nor does she point to a specific provision in the contract that beneficial allegedly breached. Notice how they never go into details of what happens. It's just assertions and conclusions, which the Supreme Court said that's not good enough to state a claim. What did they all do? Did they do vigorous detailed research? No, they're lazy. They throw rush products in front of these courts, and they think all they gotta do is say, hey, this is what they did. And the judge is supposed to be like, okay, we're going to believe everything that you did and everything is true. All you got to do is say, oh, they took my money, my promissory note, deposit to the account, loan it back to me. That's all they say. They never say how. They just say hi. They ain't got no accounting on it. They got nothing to substantiate it. It's just all assertions. And the sovereign citizen, Moorish community, patriot community only way of their teaching people is to tell them, to tell the courts, this is what happened, put it on an affidavit, and it's supposed to stand as true. I've never heard Yusuf L tell anyone in a civil suit, a financial transaction court case, on the proper understanding of presenting a claim, because even Yusuf L only teaches people about assertions and claims. We all know what happened to that. We all know what happened on that account. Loss. Just like all of them lose. Why did they lose? It's a plethora of reasons why they lose, but they lose. Makes no sense. I be trying to understand, but I can't understand something that it's all fraud. But you can tell me about who it is. We living in the feudal system. None of that means nothing in a regular transaction. None of that means nothing. Feudal system from Saul. I don't give a damn about a book, a manifesto. Do you know the X's and O's of the original transaction? Do you know the post transaction? Do you know the players to the game? Do you know all the participants? Do you know the money markets? All that other shit you talking, it don't matter. It don't matter in the transaction, because everybody that comes with the same shit that you wrote right here, we're all nationals, all this, all this, all this, it's already been rejected. It's already been rejected. It's already been rejected. It's already been rejected. I don't give a damn. National, a diplomat, it doesn't matter. It doesn't matter. Do you understand the essence of your financial transaction, or that other political shit that has nothing to do with it? What the fuck is me telling the bank I'm a national gonna do? What will it do? Nothing. Remember when I said, y'all, people choose hills to die on that aren't worth dying on? This is what I mean. Us being a national, us being a citizen, us being a resident, us being a non resident alien, us being a diplomat, us being from the embassy, us being a foreigner. What does that have to do with your financial transaction? Nothing. Nothing. I agree with you when you say it's all fraud, but you have to substantiate that from a legal standpoint, not an ideology standpoint, because everything that you said right here is ideology. It's ideology. It's ideology. I'm not a national, so I don't know my history now, because I don't claim myself as a national. Some people say I'm a citizen, so they don't know they're citizen. That's why ideologies are akin to religion. Everybody's wrong but you. Whatever your ideology is, everybody's wrong but you. That's why I don't get into that. I get into the black and white facts of an individual particular case. That's what I get into. I don't get into anything outside of the actual case and facts at hand. Because when I'm talking to these corporate professionals, when the professionals in my group are talking to these corporate professionals on my behalf, None of this shit is being brought up that you type. None of it. Has nothing to do with it. Absolutely nothing. And we try to wedge a square peg into a round hole. We try to wedge it in, and it just won't fit. These, and I'm not even saying what you're saying is wrong. But it don't matter if you're wrong or right. It don't matter in these settings. That's what I'm saying. It don't matter. This may be something you might take up with the Secretary of State that handles diplomats and diplomacies and political stuff, not any financial transaction. And with the new culture, what we're doing is we're keeping this political ideology belief systems out of financial transactions, out of it. It has no place, has no bearing in it. Prime example. Hold on. Let me pull it up. Right here. Okay, so when we get patriot, I'm a nat because they say that's what they say too. Sovereign citizens may refer to themselves as patriots, nationals. Because when you get here, you get like this is why. Federal Bureau of Investigation, Domestic Terrorism Operations Unit. Sovereign citizens believe the government is operating outside of its jurisdictions and generally do not recognize federal, state, or local laws, policies, or government regulations. And the regulations is what you need to win. Right? How about now? Can I hear me? Can I hear me? Okay, good. What do you say, Donald? You can send me the send it here. Donald, send it. Hold on. Let me show you where to send it. Let me show you where to send it. 1 second. You can send it right there. ThomasLegacy603@gmail.com. You can send it there. I'll take a look at it. I will take a look at it. And if it produces some overwhelming evidence, Donna, I don't think you can. Try to. You can try to see if you can. If you can't, you might just send it to me in the email. But I ain't on the Patriot stuff right quick. The national, I ain't on it. I want to focus on this right here. That they believe secret bank accounts exist at the United States Treasury, and that can be accessed using the Internal Revenue Service, Uniform Commercial Code, and fraudulent financial documents. Sovereign citizens believe once the documentation is filed, they gain access to their strawman account with the Treasury Department. This is these seminars and these classes they be holding on YouTube. That's my main focus. If you go back and look at all these classes from 2022, 2022, 2014, 15, 16, 17, 18, 19, 20. They were all doing this. Even the ones who claims that they got the news way better information now, they was all doing this shit. They like to act like their past ain't what it was. They know what it was. They was sitting there live doing that shit. Everybody was 1099 out. Secret trust fund account with the 1099A. File a 1099A, it gets accepted, you get a check. Right? Is to assist law enforcement in identifying of sovereign extremists sample fraudulent law enforcement badge. What does it say at top? National Concealed Carry Law Officer, HR 218. Some or all of the following may provide an indication of sovereign activity. However, it's important to note that these activities may also be indicative of lawful, innocent conduct, and in some instances may constitute the exercise of rights guaranteed by the United States Constitution. So there is a fine line. For these reasons, these indicators should be considered in the context of other suspicious behavior and the totality of the circumstances which they observed and reported, aka case by case. This is why the IRS tax returns and all this scrutiny, it's a case by case. Documentation may be mailed and addressed to the Secretary of the Treasury Department or the Depository Trust Company. Documentation includes an apostille number. All right, y'all, with the apostille numbers, sovereign citizen. Documents contain the phrase acceptance for value. All right, there go another 100,000 of you down the drain. Documents are notarized, even if not required. There go about 98%. There go 90% right there. Everybody would think we get something notarized like it's going to mean something. International postage rates apply even for domestic mailings. Well, all paperwork will be mailed using registered mail. Stamps will be affixed near the signature line or at the bottom corner of the page. Written in all capital letters. Example, John Smith. Name will be written last name, first name, Smith John or Smith, family of John. Just like Gene Keating, family of Keating, right? Zip codes enclosed in brackets. That's a context one there. Presence of thumbprints on documents. Typically in red or blue ink. Well, there you go right there. That's about 99.9. That's about 99.9 right there. That's about 99.9. I mean, Sean, the last place I'm putting all this stupid shit on the record, I think that's the last place. Like, I believe, like, I don't like putting it on the record. I mean, I agree. Not on the records. I don't know about the records. I don't know why they putting all this shit. I don't know, putting this shit on the records. We have here, U.S. citizens are property. U.S. national state citizens are not. Which do you want to be? I just want to be the one that just recouping what's owed to me, so I can go ahead and make him do everything else. Hey, one thing about it, one thing I know about the IRS, your status depends on what you filing. That's one thing I know. As far as being a U.S. citizen or not, I really ain't got no problem being a U.S. citizen, because I know once I engage in a finance transaction, all my rights, everything that I'm entitled to, from everything from real results, real checks coming back, real set-offs coming back as a U.S. citizen, I don't mind being a U.S. citizen. What is sovereign living soul? I don't know what that, well, they do not operate as a group or have an established leadership. Rather, they act independently and loosely affiliated groups which come together for training, to assist with paperwork, and socialize based on sovereign ideology. Sovereign citizens refer to themselves as free man. Sovereign citizens believe the United States government is legitimate and have drifted away from the true intent of the Constitution. As a result, the USG is not perceived to be acting in the interests of the American people. These groups generally do not adhere to federal, state, or local laws. Some sovereign citizens believe federal state officials have no real authority and will only recognize the local sheriff's department as the only legitimate government official. Other law enforcement officials have viewed as being oppressive and illegitimate. Individuals who adhere to this ideology believe their status as sovereign exempts them from U.S. laws and the U.S. tax system. They believe that the U.S. Federal Reserve System, the Treasury Department, and banking systems are legitimate. Therefore, one of the perceived benefits of being a sovereign is not paying federal or state taxes. U.S. sovereign citizens view the USG as bankrupt and without tangible assets. Therefore, the USG is believed to use citizens to back its currency. Donald? Donald? Got some explaining to do, Donald. God is a sovereign. I believe that. God is a sovereign. I agree with that. I agree with that aspect. I agree. I ain't got nothing to say about that. God is sovereign. I believe that. Have no arguments with you there on that one. But this right here, U.S. citizen sovereign, it's like they had something to believe as U.S. citizens to back the U.S. currency. Sovereign citizens believe that USG operates solely on a credit system using American citizens as collateral. Sovereign citizens exploit this belief by filing fraudulent financial documents charging their debt to the Treasury Department. In addition, they routinely engage in mortgage, credit card, tax, and loan fraud. To declare one's status as a sovereign citizen, an individual usually takes specific steps to renounce his or her citizenship. Once these steps have been completed, sovereign citizens believe they will be exempt from USG laws and taxes. Oh, hold on one second. Let me go back up for a second. I wasn't reading the fine. Okay, hold on. Let me read this box right here. Sovereign citizens often carry fraudulent identification documents. Wow. During a traffic stop or arrest, they may produce documents indicating law enforcement does not have the authority to stop their vehicle. Sovereign citizens may also write the term no liability accepted above their signature on a driver's license to indicate that they do not accept it as a legal identification document. Sovereign citizens may also create and display fraudulent license plates. Boy, they would be mad as hell if they knew if they was in this live right now. Woo wee! Documents filed to declare sovereignty. Active reaffirmation and character and renunciation of attempted expatriation, termination, separation, and divorcement affidavit, notice of sovereign status by common law affidavit, declaration of notice of expatriation, birth certificate, social security card, UCC1. An individual must file first documents with the Secretary of State office declaring his or her sovereignty. Documents which are filed to denounce U.S. citizenship include an act of state, UCC1, copy of the birth certificate, and a social security card. Once the receiving office files the documents, an apostille is generated acknowledging the documents have been correctly filed. Once the sovereign citizen receives the apostille, they view this as the United States government acknowledging their newly acquired sovereign status. So basically, once it's, even if the Secretary of State files the documents, because by law they have to pretty much file everything that comes through. Once it gets filed back, they really think that the Secretary of State really knows what they're doing and understands what they're doing and still going along with it. And they're probably not reading it. They're just filing it. But when they get the apostille back, they really think that, okay, this is stamped. So when they get met with a situation and it's not being honored or recognized, they're like, oh, what the hell's going on? It's on file with the Secretary of State. I think that's what happens. I think that's what happens. International rights of travel. Passport, Treaty of the World. The Tulka Tribal Identification Card. Unity, Washita Nation. Get your ID cards, y'all. Get your IPP cards right there. Fraudulent uses of apostilles by sovereign citizens. Secretary of State. Sovereign citizens are known to utilize a number of fraudulent schemes to defraud banks, credit institutions, and the United States government. The most prevalent is referred to as the redemption scheme. Sovereign citizens commonly engage in this type of, not that passport though. What's our oldest? What's good? Hey, he said not that passport though. That passport was shitty as hell. And that passport, that shit was shitty as hell. Hey, yo, that passport was shitty as hell. See what y'all talking about, man. I believe self-made, brother. Self-made. I believe. I believe so. I've seen people tell me about 1,001 step process and never came back. Just like with Otis Who, we had that young boy on the show. Now, down to some volunteer, some aspects of what you're saying about that is true. From when I look at that from a financial standpoint, a consumer transaction, consumer law standpoint, I get what I see what you, from a legal standpoint, I can see what you're saying in that. I understand what you're saying with that from a legal standpoint. Now, from an ideology standpoint, I understand what you're saying with that from a legal standpoint. I understand exactly what you're saying. I understand, especially with these transactions and what goes on post transaction. I get it. Just like your down payment, that ain't your motherfucking fee. That's their fee. They owe that on the books. FBI government. I can show you FBI government on the books. Come knock on my door. I can show you on the books. Oh, the Sooner building. Oh, no, I was watching. I was working. I tapped into you live the other day. You and Haitian. Y'all funny as hell. He said, not that passport. That passport was city as shit. Donald! Let me see if I have it for you, Donald. Let me see if I have it for you. I don't think I think I took it down. Fuck, I deleted it. A lady tried to go to the Bureau of Fiscal Service and get her birth certificate, Social Security card redeemed. And she said that the Bureau of Fiscal Service responded saying that is a sovereign citizen birthright scam. Your Social Security card and your birth certificate are not securities. And there are no entitlements to any government account, which just because you possess those documents. If you continue to send these fraudulent claims in, we will report the matter to the Treasury Inspector General. We consider this matter closed and we will not respond to any more of your fraudulent claims. Basically what they saying. So if you're talking about monetizing the birth certificates directly, I don't believe that's actually true. I don't think they do that. Now, they may monetize our cash flow claims they have against us, but actually monetizing the birth certificate itself, there's no evidence that says they do. And any account, anything that you're entitled to, it's never secret. You should be able to find it. If it's legit, I'll find it. I've never found any account that's been established solely a monetary account. When you're talking about a Social Security account number, monetary account, deposit account, financial account established just to represent the value of a birth certificate. It's not on the books. He said he got mild symptoms of the bug, but yeah, I don't think Donald all the way there yet. I think if he get a few more antibiotic shots, he'll come over to this side and learn the official legal way of things. He's got, hey y'all, we just gotta get Donald a few antibiotic shots, some nitroglycerin. Just give him a few. You just need to get a few shots. Come to a few classes or two. He need just get a little shot. That's all he need. Donald ain't too far gone in La La Land. He just need a few shots. That's all. This is from the FBI, by the way, for those who just tuning in. Thank you. Hit the like on the way, y'all. Even if you don't like it, you can hit the thumbs down. It's cool. It still counts the same. I don't know why people say that, because then people don't hit it at all. When they know that it counts the same, they don't hit it at all. Remember, people used to be that they ain't like your video. Remember back then, YouTube, they used to have the thumbs up button and then the thumbs down. So you may have like 3,000 likes, about 200 dislikes. You notice how it never shows a dislike, because people know now, even when you click the dislike, it works just the same as the like. Why do you think nobody hits the dislike anymore? They just won't hit the like. No, literally, the dislike works the same as a like. A dislike, you can have 1,000 dislikes. It's still going to bring people to your channel. Want to know why? Because you had to be watching in order to dislike. They don't look at the fact that it was dislike. They look at the fact that you got 1,000 dislikes. They're looking at the fact that 1,000 people watched this video. They don't hold people's personal preference against you on here. The redemption scheme is based off the belief that the United States government went bankrupt in 1933, subsequent to the passage of House Joint Resolution 192. That alone would give me reason to never put HJR 192 in my documents, because it's going to trigger this. I would never put this in any document. For those of you who still add it to your documents, even though I debunked it like 5 times, just by this public law that's on the FBI domestic terrorism unit memorandum, I would stay as far away from HJR 192. Imagine the people who will wholeheartedly believe in those processes because they actually needed the money for their necessities of life. Imagine them sitting here reading this right now. They would be sick to their stomach. Oh, they'd have been left. No, I don't want to see anything that's going to contradict my belief system. I believe what I believe. I'm going to leave now. I do appreciate the fact that even though we may have different opinions in this, y'all, you still sticking around, because I ain't about to sit here and tell you you're wrong all day. That's your life. Believe what you want. Do you? Subsequent to the passage of HJR 192, effectively removing. Hold on one second. Whatever. Removing the United States government off the gold standard. Sovereign citizens believe the U.S. declared bankruptcy when the USG was removed from the gold standard. As a result, U.S. currency, referred to as Federal Reserve notes, is perceived as valueless credit notes. The monetary system is now believed to be based on exchanging one credit document for another. Why did they put that there? Why did they put that there? Because I could show you exactly black and white from a legal accounting standpoint. That's exactly what's happening. I wonder why they put that there. I wonder why they put that there. That's interesting. I thought they would have left that part out, because I could show you that black and white on the books. Sovereign citizens believe this makes U.S. currency essentially worthless. Absent the gold standard, the USG needed securities to participate in global trade. Yo, what the fuck are they saying? Oh, see, I see what they're saying. They're talking about the people who thinks the birth certificate and social security numbers are the actual securities needed to participate in global trade. I get it. I get it. It's context. I was going to say, I know you ain't saying securities as a whole ain't a big reason for global. I know y'all ain't saying that. I could point y'all to about 30 different Department of Treasury statutes, regulations, acts of Congress. So I gotta say, so they ain't talking about those securities. Treasury bonds, treasury notes, instruments that mature beyond nine, And they ain't talking about those. They talking about, like, let me see this read. So sovereign citizens believe the USG issues social security numbers and birth certificates as means to register US citizens for use as collateral to be used in trade agreements with other countries. Okay, so they talking about the securities as far as the birth certificate and uh hold on, y'all. Nah, Donald good. Donald good. Y'all, Donald good. Donald good, y'all. Y'all, Donald good. Mr. Wiley, Donald good. Damn, Donald. Donald, you can come back. Now, Donald was good, y'all. He wasn't being disrespectful or nothing. He wasn't being disrespectful or nothing. Yeah, Donald good. He wasn't being disrespectful. He giving his view. He wasn't being disrespectful in his views. Yeah, Donald wasn't being yeah, I forgot to tell y'all. Yeah, he wasn't being disrespectful. I hope he come back. Yeah, he could. Yeah, he wasn't. Yeah, and Mr. Wiley, he wasn't being disrespectful. Oh, I'd have been got him out of there. Nah, Donald, you all right? Donald, you all right? You good? You ain't being disrespectful. As long as you stay respectful, you ain't being disrespectful. It was a little air. Yeah, y'all. Donald good. He ain't gotta go. Even though we got difference of opinions, he ain't gotta go. He ain't being disrespectful. 1933 bankruptcy. Mr. Wiley's one of my mods. He cool. Everything cool, y'all. Misunderstanding. Let's just move forward. It don't matter. Move forward, Donald. You back here, so it ain't even an issue. Just sharing knowledge. 1933 bankruptcy of America. Hey, Donald. One thing you gotta realize, I've studied extensively on the American, the government from 1929 to when they was passing all those series of acts and laws. Oh, let me ask you this. Hold on, Donald. And nobody answer. I only want Donald to answer this question. Is the Emergency Banking Act is the emergency declared with the March 9th, 1933 Act still in effect to this day? Donald is the only one to answer this. If you answer this question, you're not Donald, you will be banned. When I ask Donald only, is the emergency declared from the March 9th, 1933 Act, is that emergency still in effect today? They got 1,000,001 emergencies, like other different countries. Yeah, they stay under 1,000,001 emergencies. But I want to the March 9th, 1933 one, are they still in that emergency? Let me know. I'm gonna continue to read this. Let me know your answer. Under this system, the U.S. Treasury Department creates an account for each citizen containing their monetary worth. Hey, Mr. Mr. Donald, you say you're in your mid-60s. Okay, so I'm gonna give you that respect as my elder, Mr. Donald. I was around a lot of guys that is probably your age and probably a little older, so y'all pretty much got the same understanding knowledge of the system, but the government, you in your mid-60s, right? So you understand that it's this whole country operates off debt. Like the government, Donnie say he did that on accident. It's all right. Yeah, it's all good. So, Mr. Donald, the government can never really pay off its debt. If you paid off his debt, we wouldn't have, everything runs off debt. So you can't really have in a fiat currency system, you can never really have a debt-free country. You know what I'm saying? Like it's kind of impossible because you always got to issue debt in which somebody else is paying you to pay somebody else. That's kind of how the like capitalistic. We're in a capitalist country, free trade. Well, supposed to be free trade, but I don't think the government, and y'all can chime in too. I don't think the government would even want to pay off its debt. When I mean pay it to the fact that, because think about this. If you are a very large holder in government debt, and I'm talking about you own hundreds of thousands of treasury securities, do you know that your interest alone, that's what you're living off? And do you realize when it's time to be cashed out, they give you the option of you can cash it out whenever you want, or you can be issued another security. A lot of people, if you got a significant amount, you'll be issuing another security because you can still live off the interest and keep the principal there. Like, let's say I own 250,000 government securities. I would never want to cash all of them out when they mature. I would rather be issued new securities and draw the interest. That's a fact, because the securities market, it's not just what you're getting principal interest off one security. The security is a financial asset. So you can trade that security. I give you, I want this property. All right, I'm going to assign 100,000 of my securities over to you. You see what I'm saying? It's a bargaining chip. Securities have replaced bartering as a bargaining chip under this current system. Under this system, the U.S. Treasury Department creates an account for each citizen containing their monetary worth. These accounts are commonly referred to as U.S. Treasury Direct Account. These accounts believed to contain tangible assets in amounts ranging from 630,000 to 300 million. Sovereign citizens refer to this as the dollar value of credit. Sovereign citizens believe that their U.S. Treasury Direct accounts are in the name of a third party created using their name. These third parties are referred to as Traminius Homo, corporate person, government entity. Sovereign citizen use the phrase free money from the straw man, referred to extorting money from the Treasury Department. I ain't never heard of that term. Oh. Documents they use: Federal Reserve note is a credit slip indicating the United States government will provide something of value in the future. Using this assumption, Sovereign citizens file fraudulent financial documents to exchange credit for credit. As an example, rather than paying for a car with Tamika, listen up, girl. Tamika. Somebody tag Pass the Freedom. Somebody share this to Pass the Freedom. Tamika. As an example, rather than paying for a car with U.S. currency, the sovereign citizen will produce fraudulent financial documents such as a promissory note, site draft, or offset bond, which offers to provide something of actual value at a future date. Steps to free money from the straw man. Sovereign citizens use the following steps to obtain money from their U.S. Treasury direct accounts, also known as their straw man, to fraudulently eliminate debts. To complete the process, sovereign citizens typically files the following forms. A UCC-1 with the Treasury Department, locking in their U.S. Treasury direct account. Notifies the Treasury Department that the individual intends to use their Treasury direct account. An acceptance for value with non-negotiable chargeback. Oh, that's straight from the old redemption manual. Request of release of funds credit from the U.S. Treasury direct account. This is not a legitimate document. Therefore, the Treasury Department does not typically respond. Acceptance of the chargeback. Informs the Treasury Department others have failed to respond to the sovereign citizen's request, and a lack of response is assumed to indicate the U.S. Treasury direct account is available for access by the sovereign citizen. The Uniform Commercial Code was first published in 1952 as part of an effort to help standardize commercial transactions throughout the United States. Sovereign citizens commonly use three legitimate UCC formats for fraudulent filings. UCC-1, used to secure a loan under the UCC. UCC-3, for changes or termination of a UCC-1. UCC-AD, to amend a UCC-3. These are the forms that they use. Using straw man funds to satisfy debts. All you teachers, this is about you right here. All you teachers, there you go. I got something for you. I told you I was going to have something that personifies y'all teaching. Told you I wasn't going to let you down. Now, I can't even name all the names. Just know that 98% of your teachers, this is what their class pertains to. Getting something for nothing. When the sovereign citizen receives a bill, credit card, tax, mortgage, a chargeback notice is sent to both the creditor and the Treasury Department. This notifies the creditor of the U.S. Treasury direct account and designates the Treasury Department as the responsible party for the debt. The sovereign citizen acknowledges the amount owed to the creditor by sending the creditor an acceptance for value, a bill of exchange, bond to discharge debt, affidavit of payment of tender, and banker's acceptance note are then sent to the creditor. All are fictitious obligations issued to pay off the debt. An identified sovereign citizen will provide an identified creditor with chargeback instructions, which explains the process of submitting documents to the Treasury. If the creditor refuses to accept the documents, payment demands will be made using a notice of notarial protest, notice of non-response, and administrative record of non-response documents. These documents are commonly sent by a notary or individual claiming to be a legal representative. Documents will threaten legal action against the creditor. I told you they always got threatened. The sovereign citizen may also take the following actions. Submit a notice of arbitration to inform the creditor they must agree to binding arbitration to resolve the dispute. The arbiter is usually a sovereign citizen or supporter. File an affidavit of fiduciary, naming the creditor's lawyer or law firm as the sovereign citizen's counsel. This creates a conflict of interest since the attorney is ethically prohibited from representing both parties. File an IRS 8300 form to the creditor to fraudulently indicate the creditor has additional unreported income. Yeah, they tripping. Criminal sources of income from sovereign citizens. A number of individuals are known to travel throughout the United States teaching fraudulent techniques to discharge debts to interested parties. Joe Debate. Hey, Joe Debate. Hey, Joe Debate, tap in if you're listening, man. I'm gonna get one of your I'm gonna go to one of your live seminars. Hey, Joe Debate, I need an injunction too. The joint that you sold down in Atlanta, I need that injunction. Damn. For a lot of you, my victims out there, don't this seem like a lot of the stuff that y'all pay for? Right, all sovereign citizens. And this is why the teachers hated me, because I was uncovering it's all sovereign citizens. A number of individuals are known to travel throughout the United States teaching fraudulent techniques to discharge debt to interested parties. A fee is charged to attend seminars which provide information regarding redemption schemes and other methods to avoid paying taxes. In addition to conducting seminars, several trainers are known as to sell CDs and DVDs containing material from the seminars. A lot of them do that. Tazadat, he got DVDs. Sovereign citizens may sell fraudulent documents to other like-minded individuals and illegal immigrants. Remember? Sovereign citizens may sell fraudulent documents to other like-minded individuals, meaning you're not buying it unless you already have the same belief system. These documents include, well, what do you know? Driver's license, passports, diplomat identification, IPP cards, vehicle registrations, concealed carry permits, law enforcement credentials, insurance forms. Some may also generate income by providing consulting services to those who need assistance in preparing sovereign citizen paperwork. Boy, don't this sound like the hallmark YouTube teacher space right here? Yes, this was put out by the FBI, who's actually prosecuted these people. Yeah, people actually go to prison behind this stuff. One of the main sovereign citizen components got 20 years. Then the main one got 20 years. So, 20 years for a lie, 20 years for they just want to silence him. 20 years? Is that really worth a hill to die on? You know one thing about sovereign citizens? They don't ever have any legal viable resources or income outside of their sovereign teachers. You notice that, right? You notice that, right? You do notice that, right? They ain't got no investment property. They ain't got no timeshare that they sell. Put on Airbnb. Guess what I got? I got to file investment income every year. Well, I don't personally have to file it, but the company that I set up and my stepdad runs, they file it. They don't have jobs. They're not gainfully employed. If no one takes their class for 90 days straight, they will be fucked up. And nobody comes on their live for 90 days straight so they can monetize their channel. they will be fucked up. Sovereign citizens may generate income through use of mortgage fraud. Watch out, y'all. Watch out, y'all. Because they all telling you that's the biggest thing that a lot of people need. They're all telling you that they can get rid of your mortgage. Watch out. They're all telling you that they can get you this. They telling you that they telling you a lot of things now. They all telling you that they can get you this. They telling you they can get you that. But you're gonna end up in the you're gonna end up in it's gonna be a lot of trouble. There are many ways these individuals propagate this crime. One example is the sovereign citizens first established contracts with real estate companies who identify sellers listed with the company who may be vulnerable targets for fraud. What? Dang, they get sophisticated. Sovereign citizen purchases the property using fraudulent financial documents and then has the property appraised at a higher than market value. A mortgage or line of credit is obtained utilizing the inflated property value. The sovereign citizen then either absconds with the funds or uses the line of credit to fund other fraudulent activities. God damn. What the hell? Uh, Hold on. Sovereign citizens use a number of tactics to harass, intimidate, and psychologically threaten agencies and individuals who interfere with their fraudulent practice. This often includes federal, state, and local government officials and employees of financial institutions. If law enforcement or government officials attempt to take legal action, either criminal or civil, against sovereign citizens, the official may be perceived by the sovereign citizen to be acting without legal authority. When this happens, one or more of the following steps may be taken against the officials by the sovereign citizens. Liens. Damn. Shedrick, I hope you watching, bro. Sovereign citizens believe their name is their personal property and cannot be used by others without their approval. They believe their names are copyrighted or trademarked and that the unauthorized use of a sovereign citizen's names entitles them to a financial remedy from the offender. Y'all remember Shedrick in the group yesterday? Shedgy Swedge. That's what I'm trying to tell you, bro. Ski, they already on it. In their view, allows them to file a lien against the offender to collect the debt. I'm not gonna get it down. They got notice of dishonors, all this type of shit. Bills and bounties. Many sovereign citizens believe government officials must sign an oath of office upon assuming their position, and this oath of office defines officials of legal authority while serving in that position. They also believe officials must post a bond, common law jury. It's just a whole bunch of shit. They file lawsuits against law enforcement office. All this, if you know anybody that done any or more one of these things from an extended period of time, more than likely they are a sovereign citizen. 8,300 forms. Suspicious activity reports. Currency transaction reports. Yup. Yup. Sovereign citizen trainers in prison will also attempt to recruit new individuals to the sovereign citizen. That's exactly what they try to do. That's exactly what they try to do. That's exactly what they try to do. I said, hell nah. Historically, some sovereign citizens have committed the following violations: felonious police killings, liens and threats against federal officers, bank fraud, mail fraud, wire fraud, mortgage fraud, conspiracy, fictitious obligations, coinage similitude, passing, uttering coins of silver or gold, money laundering, tax violations, possession of firearms by a prohibited person, illegal sale of a firearm. Common statute that the U.S. Federal Criminal Code used to prosecute sovereign citizens. Title 18 U.S.C. Section 2, 111, 115, 3, Section 2, aid and abetting. 111, assaulting an officer. 115, threats against a federal officer. 371, conspiracy. 372, conspiracy to impede or injure a federal officer. 373, solicit to commit a crime of violence. 45, maker of forging counterfeit coins or bars. Good God Almighty, they hit him with all this. Oh, you doing some time behind this. The Court Security Act, damn, they even branded up the court for these people. The 1099 form is legitimately used to report income other than wages, salary, and tips. Sovereign citizens use the form to fraudulently pay debts. The 1099 OID is legitimately filed with the IRS if possession of a financial instrument results in gross income in excess of $10. To fraudulently discharge a debt, sovereign citizens complete the form designating the creditor as the recipient. The amount of the debt is listed in the withholding section. When the form is processed, the amount listed as withholding is believed to be placed in the sovereign citizen's strawman account as credit. A 1040 is filed with the IRS to obtain a refund for the amount stated in the withholding section of the original 1099. Acceptance for value. They think it forms a binding contract with the receiving party. The value of the contract is considered the property of the sovereign citizen. If a sovereign citizen writes acceptance for value on a document, they are acknowledging the terms of the contract, recognizing the contract limits in their rights, and waive their right to any legal remedies. By acknowledging the terms and limitations, the sovereign citizen is not indicating a willingness to adhere to them. Instead, the person is indicating a willingness to negotiate the terms of the contract. So, do you realize when they sign it, it means something else than what they think it is, because they only think it means something because someone told them the ideology. Instead, the person is indicating when since sovereign citizens believe the U.S. government operates on a credit system and no tangible assets back for the reserve notes, actual bills are viewed as one form of credit requesting payment from another. That's why they think that when you get a bill, it's a bill of exchange. Therefore, the terms are negotiable. Examples of a contract could be a bill, mortgage, loan. A sovereign citizen receives a credit card bill which states the amount owed on the account, an interest rate for the card, and a payment plan. By writing acceptance for value on the bill, the sovereign citizen acknowledged the contract was received. The amount owed, interest terms, and payment schedule are considered to be negotiable items, which once accepted for value could be negotiated with the billing company. Well, affidavit of fiduciary, affidavit of truth, bills of exchange, site drafts. These documents are fraudulently created to pay creditors. These documents will either appear to look like a letter or designed to look like a legitimate check. Fraudulent checks may be issued to banks or creditors to discharge debt. Typically, these documents designate the payer as the Treasury Department, the Comptroller of the Currency, or the Commissioner of the IRS. Check for account numbers at the bottom of the edge. And fraudulent created will not be encoded. Bonded promissory note, private registered bond for set off, non negotiable. Private registered offset and discharge bond, and private registered indemnity bond. Straight out the Sovereign Citizen Redemption Manual. That's what comes with the Redemption Manual. Those are the templates that come with it. Sovereign citizens issue these bonds who access funds in their Treasury Direct account. Typically, there's a stipulation requesting the recipient respond within a specific amount of time. Non-response is viewed as an acceptance in honor of the bond, the associated transaction, and presentments. Bonds expire at the specific time period, typically upon the death of the author. The goal of the bond is to allow the file to pay debts using their Treasury Direct account. Corporation sold. Oh, so everybody. Oh. So basically what they saying is sovereign citizens use religious groups to be 501c. Wow. Notice of arbitration. UCC filings. This is pretty much everything people teach. They got it on here. Pretty much everything people teach, they got it on here. That was wild. Then there, everything these people teach, yo, they got people crashing out like that. Y'all, check the link. I shared it. Let me see the link. I don't see the link. I don't see the link, Mr. Donald. Mr. Donald, I don't think it's there to brainwash their employees. I think that that's just how they're going to look at it initially. But then you got to know what you know to get through the door. That's what I think it is. I think it's more of a you gotta substantiate your claims even more, and then it can't look like nothing that they normally see. So I think they're just putting that up to separate the wheat from the chaff, if that makes sense. I don't know where the link at. I don't know where the link at, Mr. Donald. The brainwash employees. Yeah, nah, they ain't gonna let the employees know what's really going on. Think they really. Do you think they let you really own property? If so, how can they tax it? There's always nuances to it, Mr. Donald. We may know some things to be true, but if there's already a status quo, it's going to be hard to get our truth, you know, we know some things ain't what it see. We get that, but it's all about picking your spots and not flying too close to the sun. That's all I'm saying. You could do. Yeah, you can look at it like that. Yeah. Yes. You say you put it. I don't see it. It's not here. It's not showing up. Send it to my email. And I'll review it my next class. I don't see, it's not showing no link. Y'all see a link? Hold on. Let me scroll back up. I don't see it, Mr. Donald. I really don't. And the sun is closer than they tell us. That's why you gotta use discernment. Lot is at the bottom. Hold on. I don't. It's not here. It's not popping. Just send it to my email, Mr. Donald. But hey, the sun may be closer than we think. The sun may move. The sun may set. You got to use discernment. You got to know what the game would fit out. But what I'm saying is, I wouldn't use anything that remotely resembles any of those triggers for them. That's why the best way to protect yourself, appropriate acts of Congress, statutes, regulations, county standards, everything that the corporations use. They don't ever call them sovereign citizens. When it have the corporations do it, I follow their model because they know what they're doing. But if a corporation is doing it, it's done right. Majority of the cases. If a corporation is doing it, it's done right. Majority of the cases. I don't care what. Accounting, tax forms, consolidated balance sheets. Corporation doing it, it's done right. And with that being said, y'all, I gotta go. I gotta give me something to eat. I gotta get ready. Boop, bop, bip. Boom, 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 boom. We knocked them out the park again today, y'all. Boom, boom, knock them out the park. Boom, boom. Remember Pops? Remember Pops, y'all? All right, y'all. One gone. We up out of here. We is up out of here. Gotta go.